Okay, just so everyone's aware, we are live streaming now. Just waiting for the all clear. All right, we have the all clear so we can get things started. Let's call the case of the state of West Carolina v. Timothy Ray. My name is Judge Courtney Klabina. Scoring judges, I believe you all have your audio and your video already turned off. Just make sure it stays that way until the trial ends. And then all of the advocates and team members, obviously, if you are not the witness or the advocate who is handling a given examination, you should have your audio and your video turned off as well. So before we get started, let's go forward with appearances, starting with the prosecution.
Good afternoon, Your Honor. My name is Surgeon Aurora, and along with my co-counsel,
Haley Naughton.
Today we represent the state of West Carolina.
Right in defense? Are the defense advocates on?
I believe that you're on mute.
Good morning, Your Honor. Aaron Cadiz, last name spelled C-A-D-I-Z, on behalf of Mr. Timothy Ray.
Good morning, Your Honor. Jenna Forster, spelled F-O-R-S-T-E-R, also on behalf of Timothy Ray. We represent Team 114. When Your Honor is ready, we have a few substantive motions as well as housekeeping matters to present before the court.
All right, well, let's start with the prosecution side. Let's begin with any pretrial motions you have, and we'll save the housekeeping till after we make the motion rulings.
Yes, Your Honor. Today, the state has two motions in limine. First, Your Honor, we are seeking to bar the defense expert's third and fourth opinion. Today, the state has charged the defendant with first-degree murder. The defendant has filed notice of an insanity defense, and per pretrial order, this defense cannot be revoked. Now, this jurisdiction dictates that in order to prove insanity, the defense must show that the defendant was unable to appreciate the wrongfulness of his acts. In an attempt to do so, the defense has retained Major Riley, who in his report explicitly mentions that the defendant did not have the ability to understand the wrongfulness of his actions, and even more so, Major Riley in his report contends that the defendant did not have malice aforethought nor premeditation. Now, pursuant to this jurisdiction's case law in Pasquarello v. West Carolina, in a case where the defendant makes insanity his defense, those ultimate issues regarding whether the defendant knew what he was doing is for the trier of fact alone, pursuant to Rule 704B. Accordingly, Your Honor, the state moves to bar any mention of those ultimate issues from Major Riley.
Defense, do you have a response?
Yes, Your Honor. According to Pasquarello v. West Carolina, an expert may testify to the characteristics of a disease, and they are also allowed to opine as to whether that disease was affecting the defendant during the particular incident. Therefore, Dr. Riley would be able to state whether schizophrenia was affecting Mr. Ray at the time of the incident and how it would affect him in his decision-making process.
All right, so if I can be just drill down on what I think prosecution is saying, that the specific opinions of opinions 3 and 4 in Dr. Riley's report are the issue, or the things they have an issue at. Prosecution, what are those two specific opinions?
Your Honor, those two specific opinions, the first one is that the defendant was unable to appreciate the wrongfulness of his actions. And the second opinion, Your Honor, is that the defendant did not have any premeditation or malice aforethought.
And defense counsel, do you intend to have Dr. Riley testify to those two opinions, number 3 and 4 in Dr. Riley's report?
Your Honor, we intend on having Dr. Riley testify to opinion number 3.
All right, then I will need argument on opinion number 3. I believe it is specifically stating what Timothy Ray had the ability to recognize the wrongfulness of his actions at that time. I believe that is the actual opinion. How does that meet with Pasquarello?
Your Honor.
Okay. I'll hear from defense first.
Your Honor, again, Pasquarello v. West Carolina states that the characteristics of a disease can be opined to by an expert, but the expert can also opine to whether the defendant had the disease at that time. Dr. Riley is an expert with multiple scholarly articles and decades of experience. He understands the ins and outs of schizophrenia and how that disease can impact a patient. He's dealt with multiple individuals who have schizophrenia, specifically Mr. Ray, on numerous occasions, and would be able to understand exactly how that disease impacts Mr. Ray's decision-making and his ability to determine right from wrong.
All right, I'm going to grant the prosecution's motion. Dr. Riley is prohibited from testifying to opinions 3 and 4. Now, to be clear, that does not prohibit Dr. Riley from testifying that somebody with schizophrenia might not be able to appreciate the wrongfulness of their actions at given times. But the specific opinion that it was Timothy Ray at the time of the incident that could not understand the wrongfulness of his actions, that is prohibited. Prosecution, do you have any further motions?
Yes, Your Honor. The prosecution's second motion in limine is pursuant to Federal Rule of Evidence 615. We're requesting that all non-party and non-party expert witnesses be constructively excluded from the courtroom.
And
I have no objection, Your Honor.
Okay, and just that's great to know, defense counsel, just specifically so I'm aware, nobody has been designated. You're not asking for anyone to be designated as a party witness or anyone who should be in the courtroom. Is that right?
That's correct, Your Honor.
All right, then in that case, all witnesses will be considered sequestered. Is anything else from the prosecution in terms of motions?
No more motions in limine, Your Honor.
All right, then we'll go to the defense. Defense counsel, do you have any motions?
Yes, Your Honor. The defense has 2 substantive motions in limine we'd like to discuss at this time. Would the court like a brief recitation of the facts?
No, I think I understand the facts of the case. Thank you. You can go ahead with your motion.
Yes, Your Honor. We expect the prosecution to offer testimony that Mr. Ray was malingering or faking his symptoms in order to avoid potential punishment, such as the death penalty or a life sentence. Dr. LaGreca makes reference to an unpublished, incomplete study that he is authoring, where he states, quote, "Early results show that there exists a positive correlation between malingering and the possibility of capital punishment when compared with subjects not facing capital punishment." Given that this is the trial phase of this case and not the sentencing phase, we believe that it would lead to a mistrial with any mentioning of potential punishment. Further, there is a second study referred to by Dr. LaGreca where he states that 19% of subjects who are interviewed in the context of a criminal case show that they are malingering. These statements may be found on page 70, paragraph 4, as well as page 74, paragraph 4 of Dr. LaGreca's expert report. We move to exclude these statements in Dr. LaGreca's report under Federal Rules of Evidence 403 under unfair prejudice, as well as on the grounds that this is a trial and not the sentence phase of the case. And again, as I stated for the second study, we don't have the author. The defense nor anyone in this trial who was involved has received a copy of that report. Therefore, we move to exclude it because we can't test its reliability.
Prosecution response.
Yes, Your Honor. Your Honor, pursuant to Federal Rule of Evidence 703, experts are allowed to use otherwise inadmissible evidence to come to their conclusions. That's simply what Dr. LaGreca did in today's case. It's uncontested, Your Honor, that Dr. LaGreca has the skills, he has a knowledge, he's done this for a long time. Dr. LaGreca is certainly an expert in his field and therefore should be allowed to rely on facts that he became aware of.
Now, defense has raised 2 separate studies that they're taking issue with. The one that refers to capital punishment and the other, which they're saying they were not provided a copy of and there is no author. Is that your response on both of those studies? Do you understand that perhaps the one on capital punishment might in and of itself be prejudicial?
Yes, Your Honor. As to the study regarding capital punishment, the state plans to not elicit any testimony regarding that.
All right, so your response was just regarding the other study.
Yes, Your Honor.
All right, defense counsel, do you have a response? I'm going to rule that the capital punishment study is inadmissible. Do you have any response on the other study?
Yes, Your Honor. Opposing counsel cited Federal Rules of Evidence 703. However, they neglected to acknowledge the fact that the other half of 703 acknowledges that there must be a balancing test. In this case, the prejudicial effect of allowing a study that doesn't have an author, that doesn't allow us to test the reliability of this particular study, substantially outweighs any probative value it would have in this case.
Prosecution, your response on that?
Yes, Your Honor. The probative value of this study is it's something that the doctor relied on in coming to his conclusion. It's extremely probative in today's case. As to any prejudicial value, Your Honor, that simply goes to the credibility of the study, not its admissibility. It goes to its weight.
I tend to agree. As I said, I am granting the motion as regards to the capital punishment study, but I will allow the other study, Dr. LaGreff, to testify to the other study. Defense counsel, all the points you raised sound like great arguments for cross-examination and closing.
Yes, Your Honor.
Defense, do you have any other motions?
Yes, Your Honor, we have 2 additional motions. We expect the prosecution to offer photos of Nathan Ray's body as it was found at Brandywine State Park, specifically noted in exhibits 18 through 21, found on pages 95 through 98 of the case file. We move to exclude these photos as unfairly prejudicial under 403 and lacking relevance.
And can you tell me what the specific exhibit numbers of the photos are that you're seeking to exclude?
Yes, Your Honor, it's exhibits 18 through 21.
21. All right, prosecution, do you have a response?
Yes, Your Honor. Today, the prosecution has charged the defendant with first-degree murder. In proving our charges today, we will call Detective Booth. Detective Booth has to walk the members of the jury through his entire investigation to the defendant's statements, to what the detective saw when he got to the crime scene. Your Honor, the probative value of these pictures is not substantially outweighed by any danger of unfair prejudice.
All right, I'm going to allow prosecution to enter one of these pictures. I think if you were to enter all of them, it would be unnecessarily cumulative and prejudicial. So you may pick one of them and use it, no more than one. Defense, do you have anything else?
Your Honor, may I be heard as to the admission of that photo?
Sure.
The photo that will be admitted is, no matter what exhibit is chosen, ultimately a photo of Nathan's body wrapped in a garbage bag and partially buried in the park. However, the defense concedes that this is in fact how the body was found. There's no question as to the date that Nathan's body was found, and this photo is going to be used for nothing but to inflame the passions of the jury. It has no probative value that could substantially outweigh this enormously prejudicial effect.
And I'm going to stand by my ruling, counsel. Do you have anything further?
Yes, one additional motion, Your Honor. We moved to include statements from Officer Cruz that were made from Officer Cruz to Dr. Riley regarding Mr. Ray's actions on the year of in 2010. Officer Cruz will testified to Dr. Riley that Mr. Ray was seeing things for nearly a month and he was also sleepwalking. These statements can be found in Exhibit 9, found on page 60 of the file, and that's in Dr. Riley's psychiatric evaluation of the defendant in 2010. We find these to be admissible under FRA 703, and they also survive a reverse 403 balancing test.
I'm sorry, are you asking for these statements to be admitted or to be prohibited?
To be admitted, Your Honor.
Prosecution, your response.
Your Honor, we have no objection to that if it goes to if the defense can lay the foundation that it goes to the expert's opinion in today's case.
So are you saying that you might have an objection at the specific time in trial when they go to raise that, depending on the foundation that is laid?
Yes, Your Honor.
Understood. I will reserve my ruling till that time.
Thank you, Your Honor.
Your Honor, one quick point of clarification.
Go ahead.
As to your ruling regarding the one picture, that's from exhibits 18 to 22. Do I have that right?
18 to 21. When I'm looking at the case file, 22 appears to be the picture of the back seat.
Okay, one picture from 18 to 21.
Yes, so there's several pictures of essentially of the body, and you can only use one.
Yes, Your Honor.
Prosecution, do you have any housekeeping matters?
Yes, Your Honor. Your Honor, may we have standing permission to share our screen with opposing counsel, the witness, and the bench?
I would like you to consider share screen as publishing to the jury. If you are trying to direct a witness or myself to an exhibit that has not been admitted or published yet, you should be referring to the electronic notebook.
Yes, Your Honor.
So you will need to ask for permission to publish.
Yes, Your Honor. Your Honor, may we presume that all objections are heard outside the presence of the jury?
No, we will presume that they are in the presence of the jury unless someone is asked to go to sidebar. However, all sidebars will be constructive. So we're not going to go into a breakout room or anything. We'll discuss it constructively out of the presence of the jury.
Yes, Your Honor. And Your Honor, may we presume that all witnesses have been constructively sworn in?
Yes, we can assume that.
Your Honor, with that, the state is ready to proceed.
All right, defense, any other housekeeping matters?
Your Honor, nothing further.
All right, then if everybody is ready to proceed, I'll ask that everyone except for the person who's going to be doing the prosecution opening, mute and turn off your video. And timekeepers, you should be both taking time of both sides as well. So let's just make sure all the timekeepers are on point as well. Everybody's ready to start. Prosecution, do you have an opening statement?
Yes, Your Honor.
All right, you may proceed.
The defendant admits he killed Nathan Ray. Let me repeat that. The defendant in this case admits that he killed Nathan Ray, his own and only child. On October 17th, 2018, started out like any other typical morning for 6-year-old Nathan Ray. Little did Nathan know that this morning was going to take a turn for the worse. He's eating breakfast at the defendant's house when he accidentally spills juice on the defendant's laptop, which is unfortunate, but that's life with a child. You expect a parent to be mad, but understanding, upset, but consoling. And ultimately, that a parent would take this as an opportunity to teach their child that silly mistakes happen. But the defendant did the exact opposite. The defendant is angry. He's furious at his son. So he begins to scream at Nathan. And like any normal 6-year-old, Nathan's terrified and starts crying. He runs to his room, hoping for a safe place. But the defendant follows. The defendant storms into Nathan's room with the intent on punishing his son. The defendant decides to punish Nathan by making him do jumping jacks and high knees. But this only makes Nathan more upset. He cries for his mom, hoping she'll come and save him. And he cries that he hates his dad, hoping he'll stop the punishment. Hearing this, though, only further enrages the defendant. So the punishment gets worse. The defendant leaves the room, giving Nathan a moment of hope that the worst is over. But the defendant returns to Nathan's room with a belt. The defendant starts to beat Nathan with that belt, striking him over and over again while Nathan screams and cries for his dad to just please stop hurting him. And the defendant does stop, but only long enough to wrap the belt around Nathan's neck. The belt tightens around the child's neck as he's fighting to loosen it. The belt gets tighter and tighter around the child's neck as he's grasping for air. The defendant uses all of his strength to tighten the belt until his child, Nathan Ray, is dead. It is our burden in today's case to prove to you, beyond a reasonable doubt, that the story you just heard is true. That Timothy Ray murdered his son, Nathan Ray. And today, we embrace and will meet that burden. And here's how. You're going to hear from Detective Blake Booth, an officer of 23 years. Detective Booth is going to tell you about his investigation into Nathan's death. Detective Booth is going to tell you all about all the evidence that he found. 2 bottles of bleach, a bloody shovel, and a box of trash bags in the back of the defendant's car. Then Detective Booth will tell you about where he found Nathan's body. In a park, in a shallow grave, stuffed into a trash bag. And finally, Detective Booth is going to tell you about his interview with the defendant and how the defendant admitted he got angry with his son, admitted he punished him, and admitted that he murdered him. Members of the jury, I'm going to say this one final time. The defendant admitted he killed his son. It is uncontested that everything I just told you is 100% factual. So why are we here? We are here today because even though the defendant admits he killed his son, he's alleging that he has a mental disorder called schizophrenia and is therefore innocent by reason of insanity. But as you'll hear today, that simply isn't true. The defendant is wholeheartedly sane. And the second witness we are going to hear from today, Dr. Mac LaGreca, an experienced forensic psychiatrist, is going to explain to us exactly how we know that. Dr. LaGreca will tell us today that the defendant does not suffer from any mental disorder, rather that the defendant is malingering, which is a medical term for making it up. Dr. LaGreca will first explain how malingering recurrently happens in criminal trials, especially in murder trials, when a defendant is trying to avoid punishment for their crime. Second, Dr. LaGreca will explain how there is absolutely zero legitimate evidence that the defendant actually suffers from schizophrenia. And finally, Dr. LaGreca will explain today that the defendant knew exactly what he was doing when he murdered his son, because he tried to cover it up by hiding Nathan's body, evading the police, and now is trying to evade the consequences of his own actions. Anger is not an excuse. Rage is not an excuse. You don't cry over spilled milk, and you don't murder a child over spilled juice. But that is exactly what the defendant did here. Nathan Ray's life was cut far too short due to the defendant's inhumane form of punishment. And now it's your turn to punish this defendant for what he has done. Find the defendant guilty for the murder of his son, Nathan Ray.
All right, defense, do you wish to proceed with opening statement at this time?
Yes, Your Honor.
All right, you may proceed when ready.
Now, folks, there's absolutely no denying that what happened to 6-year-old Nathan Ray on October 17th, 2018 is tragic. And when something terrible like this happens in life, it's human nature to want to point fingers and place the blame on someone. And believe me, it's a lot easier to get up here like the prosecution just did and tell you that this is an open and shut case. But fact is, justice is not synonymous with convenience. In fact, justice requires us to look beyond convenience in order to find the truth. The truth that for years, Timothy Ray suffered from hallucinations, delusions, and disembodied voices that negatively affected his everyday life. The truth that Timothy Ray had an internal war going on inside of his mind between himself and an unseen villain, schizophrenia. The truth that on October 17th, 2018, Timothy Ray lost his battle with schizophrenia. He lost his grip on reality, and then when he finally came to, he realized that he lost his only son. Members of the jury, my name is Aaron Cadiz, and along with my co-counsel, Ms. Jenna Forster, we represent Mr. Timothy Ray. Now, as you just heard, the prosecution wants you to focus a lot of your attention on what happened on that tragic day. But in order to truly understand how a father could do the unthinkable, you have to go all the way back, over 3 decades ago, to when Mr. Ray was just a child. But you don't have to take my word for it. In fact, you'll hear from Dr. Shane Riley, an expert in forensic psychology. He'll tell you that an expert in forensic psychology doesn't start their analysis at the crime scene. No, see, they start their analysis at the patient's childhood. And when Mr. Ray was just 3 years old, he suffered neglect. His own mother, on more than one occasion, refused to feed him, forced him to take ice cold baths, and then at the age of 6, his mother was institutionalized with a severe mental illness. 4 years later, at the age of 10, Mr. Ray began experiencing hallucinations in the form of hearing disembodied voices that weren't really there. Later on in his adult life, Mr. Ray enlisted in the United States Army. But while he was there in 2010, his commanding officer, Officer Cruz, reported that Mr. Ray had suicidal thoughts and that he was seeing things. Then in 2014, during an unusual visit to Dr. Samantha DiGiuseppe's office, Dr. DiGiuseppe reported that Mr. Ray started crying hysterically and uncontrollably. In 2015, Timothy Ray started experiencing delusions, believing that his own son Nathan and his wife Jessica were planning on cutting him up with a knife and leaving him. In 2017, during another visit to Dr. DiGiuseppe's office, Mr. Ray looked as if he hadn't showered for weeks. And then, almost out of nowhere, Mr. Ray started screaming, calling Dr. DiGiuseppe a bitch, accusing her of listening in on his phone calls. In 2018, the prosecution's own witness, Detective Blake Booth, described Mr. Ray as socially awkward, as if he couldn't handle a conversation, and that he looked dirty and unkempt. All of these signs, Dr. Riley will tell you, point to schizophrenia. And you see, Dr. Riley will walk you through the DSM-5, the established rule book when it comes to diagnosing someone with a severe mental illness. You see, Dr. Riley will explain to you that to the untrained eye, these symptoms that Mr. Ray was experiencing might seem unbelievable. But to an expert in the field of forensic psychology, these are all signs of someone who is losing their fight with schizophrenia. And when someone loses that fight with schizophrenia, they lose their ability to tell right from wrong. But folks, that won't stop the prosecution from calling Detective Blake Booth, who will be forced to admit on the stand today that he failed to follow his department's directives during his investigation. And that won't stop the prosecution from calling Dr. McLaGreca, who has never been qualified to testify as an expert in schizophrenia in any courtroom in these United States. And after 2 witnesses, the prosecution will rest their case. Open and shut, right? But folks, this case isn't that simple. This case isn't about a man making excuses about some spilt milk. This case is about a man who lost his fight with schizophrenia, who lost his grip on reality, and then in the aftermath, he realized that he lost his only son. And so at the end of this trial, my co-counsel, Ms. Forster, will come before you and ask you to review the evidence, review the testimony presented before you, and ask you to return a reasonable verdict of either not guilty or not guilty by reason of insanity.
All right, prosecution. Before we proceed with you calling your first witness, I would like to ask everyone, namely the jurors, to be able to switch to gallery view so that you will be able to see both the attorneys and the witness all at once. Gallery view is up in the upper right corner of your screen. If you toggle over, it should be like 9 smaller boxes in a box. I'll just give a few moments for everyone to switch over. All right, and prosecution, you may call your first witness.
Your Honor, at this point, prosecution calls Detective Blake Booth to the stand. May I proceed?
We can consider Detective Booth and all other witnesses has already been sworn. You may go ahead.
Can you please introduce yourself to the members of the jury, spelling your last name?
My name is Detective Blake Booth, Booth.
You said you're a detective. Where do you work?
I'm a detective with the Skelton Police Department. I've been employed there for the past 23 years.
Can you walk us through how you became a detective?
I first went to college, got my associate's degree in criminal justice. Then I went to the Skelton Police Academy, received basic training. From there, I was assigned to the Gang Violence and Narcotics Unit of the Skelton Police Department. And afterwards, I transitioned to my detective role in the Homicide Unit, and I've been working there for the past 3 years.
You mentioned you work in the Homicide Unit. How many cases have you investigated there?
I've investigated 12 cases. This is the third case that I'm the lead on.
I want to talk to you about this case in particular, Detective Booth. How did you first get involved?
On October 18th, 2018, I received a call from a concerned mother, Jessica Ray. She needed to file a missing persons report for her son, Nathan Ray. Jessica told me that Nathan was last seen 2 days prior with her ex-husband, but she had not seen or heard from either one since, so she filed a missing persons report.
Do you see Timothy Ray in the courtroom today?
Yes, he is seated next to the defense counsel's table.
Your Honor, let the record reflect that this witness has made a positive in-court identification of the defendant, Timothy Ray.
The record will so reflect.
Detective Booth, was Nathan's body ever found?
Yes, Nathan Ray's body was found in Brandywine State Park.
I want to talk to you about how you found his body. Can you walk us through what happened?
Yes, on October 19, 2018, I got a call from another police officer, Officer Wentz, who was running sobriety checkpoint in downtown Skelton. He had found the defendant, who pulled him over, and he flagged him for a missing persons report. I went over to the checkpoint and found the defendant sitting on the curbside.
Did you speak to the defendant there?
Yes, when I approached the defendant, I told him we needed to take him into the police station for questioning. He understood me and said he would tell us everything.
Now, when you spoke to the defendant, was he rambling?
No,
Was he mumbling?
no,
Detective Booth, was he speaking coherently?
yes.
So what did you do next?
I told Officer Wentz to take the defendant to the police station.
Now let's talk about what happened at the police station. Once you got there, what did you do?
I interviewed the defendant about his son's disappearance.
Can you explain to the members of the jury what the defendant told you?
He told me that he killed his son. He told me how and why he did it. He told me that on October 17th, 2018, Nathan Ray was eating breakfast at the defendant's house. Nathan spilled some juice on the defendant's laptop, and that made the defendant very angry. He started screaming at Nathan. Nathan started crying and he went up to his room.
What did the defendant tell you happened next?
At that point, the defendant told me he got really mad and decided he needed to punish Nathan. The defendant first did this by making him do exercises, but that only made matters worse.
What do you mean it made matters worse?
The defendant said that Nathan wasn't really doing the exercises, and he kept getting more and more upset. Nathan kept crying and said that he wanted his mom and hated the defendant. And this is when the defendant said he needed to punish Nathan in a different way.
Did the defendant explain to you what he meant by he needs to punish Nathan in a different way?
Yes, the defendant told me he went to his room, grabbed a belt, and started beating Nathan with that belt. Nathan continued to cry, but he still kept beating him. Nathan said he hated the defendant again, so the defendant told me that he took the belt, put it around Nathan's neck, and strangled his son to death.
Detective Booth, during this interview, did you notice anything odd about the defendant?
Yes, he did ask me a few times about the CIA. He also told me that his wife tricked Nathan into spilling the juice. And finally, he did sometimes refer to himself in the third person.
Did any of those things that you just mentioned, did they affect your investigation at all?
Absolutely not. He told me when we first arrested him that he would tell me everything, and that's what he did. He openly confessed to this crime.
Did the defendant ever tell you what he did to Nathan's body?
Yes, he told me that he drove around with the body for a couple days and then buried the body in a park.
Did you find the body in the park?
Yes, I took a team of officers and canine officers to Brandywine State Park, where we found Nathan's body stuffed into a black trash bag.
What did you do next?
After that, I investigated three more items of interest. First, I searched the defendant's car. There, I collected a bloody shovel, a jug of bleach, and black trash bags. Then I searched the defendant's phone, and I looked up his internet search history on the night of October 18th.
Objection, hearsay.
Response.
Your Honor, this is not hearsay pursuant to Rule 801D2.
Can you elaborate?
Yes, Your Honor. These are search histories made by our party opponent, in today's case, a defendant.
And Ms. Forrester, do you disagree that these are, in fact, statements made by your client?
Your Honor, these statements were made by our client, but it lacks foundation as to how the discovery occurred.
Are you contesting that these are not authentic?
No, Your Honor.
All right, overruled.
Detective Booth, what did you find on the defendant's phone?
Yes, I found three search items. First, countries that don't extradite the murder charges. Second, how to get rid of a body. Third, will bleach destroy a body? Finally, I searched the defendant's house, and there I collected the defendant's broken laptop with juice residue still on it. I also took a photo of the belt the defendant used to murder his son.
Now, Detective Booth, I want to direct your attention to what has been previously marked as State's Exhibit 10, 18, 22, 26, 27, and 28. Do you have these in front of you?
Yes,
Do you recognize these?
I do.
And do these pictures truly and accurately depict those pieces of evidence as the last time that you saw them?
They do, yes.
Your Honor, at this point, the prosecution moves State Exhibit Group 1 into evidence. Your Honor, I believe you're on mute.
I was still on mute. Sorry about that. You are just trying to move Exhibit 1 at this time. Is that correct?
No, Your Honor, I'm trying to move Group 1, which includes Exhibit 10, 18, 22, 26, 27, and 28.
I'm sorry, I misunderstood you. Now, 10 is the document you were just, the witness was just testifying to. Is that correct?
The witness just testified to all of the actual pictures, Your Honor. May I be heard?
Yes, please.
Your Honor, the witness testified to what he saw in the defendant's car, what he saw in the defendant's house, and the location of the body, as well as the defendant's search history. All these exhibits, 10, 18, 26, 22, 26, 27, 28, are true depictions of those.
First of all, Ms. Forrester, do you have any objection to these being entered?
No, Your Honor.
All right, just for the record, I think we do need them identified for the record by number rather than just entered as a group, but they are admitted.
Okay. Your Honor, permission to publish via screen share?
Go ahead.
Detective Booth, can you tell us about Exhibit 10?
Yes, this is the internet search history I took from Tim's phone. As you can see, three searches. The first one, countries that don't extradite for murder charges. Second one, how to get rid of a body. Third, will bleach destroy a body. These were made on Thursday, October 18th.
What can you tell us about Exhibit 18?
This is Nathan Ray's body in a shallow grave found in Brandywine State Park, wrapped up in a trash bag.
What about Exhibit 22?
This is the back seat of the defendant's car. You can see a shovel, jug of bleach, some trash bags, and a car seat.
And what about Exhibit 27?
This is Nathan's bedroom with the defendant's belt on the floor.
And 28, Detective Booth?
This is the spilled juice on the kitchen countertop.
Now, Detective Booth, was there ever an autopsy done on Nathan's body?
There was, yes.
Did you read that report?
I did.
I'd like to direct your attention to State's Exhibit 6. Do you recognize this?
I do.
What is this?
This is the autopsy report that I ordered for the investigation.
Does it appear to be a true and accurate copy?
Yes.
Your Honor, at this time, State moves State Exhibit 6 into evidence.
Ms. Forrester, am I correct that you've already stipulated to the admissibility of this document?
Yes, Your Honor.
All right, it is entered.
Permission. Detective Booth, what does this report say caused Nathan's death?
The coroner determined that the manner of death was by asphyxiation, consistent with a belt being wrapped around Nathan's neck, which is exactly how the defendant described how he ended his son's life. The coroner determined the manner of death was homicide.
And based off all this evidence, Detective Booth, what did you do?
I charged Timothy Ray with the murder of his son, Nathan Ray.
No further questions, Your Honor.
Defense counsel, would you like to cross-examine?
Yes, Your Honor. Detective Booth, let's talk about some of the training that you received at the Skeleton Police Force. Despite everything that we just heard on direct, you couldn't tell us the signs of schizophrenia, could you?
No.
Objection, Your Honor. Improper opinion. May I be heard?
Go ahead.
Your Honor, on direct, we've established that Detective Booth is a detective for the Skeleton Police Department. He's not a psychiatrist. Of course, he can't tell us about these symptoms of schizophrenia. That's not what he's here for.
Ms. Forrester,
Being heard?
go ahead.
Opposing counsel just testified to the exact question that I was listening from Detective Booth, whether or not he was capable of determining this. The jury needs to hear whether Detective Booth himself knows and is able to identify the signs of schizophrenia. As opposing counsel just testified, he cannot, but they need to hear that from Detective Booth.
I will allow you to ask that one limited question, but there should be no further questions going into his medical knowledge.
Yes, Your Honor.
And Mr. Aurora, feel free to object again if you feel that she is crossing that line.
Yes, Your Honor.
So Detective Booth, again, you wouldn't be able to tell us the signs of schizophrenia.
No.
Now, Detective, you knew Mr. Ray before the incident, correct?
Yes.
Right. And your sons had played soccer together, is that right?
That's correct.
And it was at those soccer practices that you noticed that Mr. Ray sort of stuck out.
Yes.
He was dirty and disheveled.
Yes.
He was hard to talk to.
Yes.
He was socially awkward.
Yes.
Mr. Booth, Detective Booth, Mr. Ray just didn't fit in.
Can you repeat the question?
In your opinion, Mr. Ray just didn't fit in.
Yes.
Now, Detective, let's talk about your role in this investigation. You were the lead detective on the case.
Yes.
So it was your job to collect all the evidence.
That's correct.
And you made sure that you ran an above board investigation.
That's correct.
Right, and you made sure that you ran a thorough investigation.
Yes.
And you did that in every case, but especially in this case.
Yes.
Because if you didn't, it might look like you were hiding something.
Possibly.
Detective Booth, if you didn't keep all the relevant information, it might look misleading.
Possibly.
Well, let's talk about that a little bit, about your thorough investigation. Detective, in this case, in the case of a dead child, you conducted a thorough interview with the defendant, and that amounted to one single page?
I believe so, yes.
And Detective Booth, when you were conducting interviews after the incident, you only spoke to a total of 2 people?
Yes.
You spoke to Officer once,
Yes.
and you spoke to my client.
Yes. And Jessica Ray.
But not after the incident, right, Detective?
I did speak with her after the incident.
Detective, I believe you spoke with the Jessica when she filed her missing persons report and quickly about that you had found Nathan's body, but you never actually interviewed her.
Let her know what I found out about Nathan's body after the interview with the defendant.
Right, so you didn't interview Ms. Ray because you stuck to those 2 interviews because in your mind, the case was open and shut.
Yes.
So open and shut that when you did that 1-page report, you made sure that it focused on what you're calling Mr. Ray's confession.
Yes.
Because that confession, that was important.
Yes.
And again, when you have important information like that confession, if you don't hold on to it, it might look misleading.
Yes.
All right, Detective, well, let's talk about that a little bit. The statement that you got from Mr. Ray, you said that there was a little bit of odd moments in it. Is that correct?
Yes.
In fact, you stated that Mr. Ray actually asked you about the CIA.
Yes.
But Detective, you had testified about this statement previously, right?
Yes.
And you had that testimony at the preliminary hearing, is that correct?
Yes.
And at that preliminary hearing, you were testifying under oath.
I believe so, yes.
So you knew the importance of conveying accurate facts.
Yes.
But still, it's at that exact hearing that you said Mr. Ray never said anything about the CIA.
I was referring to the checkpoint.
Detective, you did say in your interview that Mr. Ray never said anything about the CIA.
Yes.
Now, when you mentioned at the preliminary, when you didn't mention anything at the preliminary hearing about the CIA, that might have been a little bit misleading, right?
Objection, Your Honor.
Basis?
Improper opinion as to what a judge might find misleading at a preliminary hearing.
Response?
Your Honor, Detective Booth just previously testified that if he was to hold back relevant evidence, that may be misleading. Now he's testifying that he withheld relevant evidence, and that would, by the equation that he's just laid out for us, be misleading. I wasn't asking as to the opinion of the judge or the jury, just whether he would find that that was misleading.
Mr. Aurora, anything further?
Yes, Your Honor. This line of questioning is specifically directed to what this evidence and how it would come out at a preliminary hearing, specifically how it would come out to the judge. This opposing counsel is asking this witness specifically as how the judge might take this evidence, not as how he takes it.
Your Honor, I can rephrase if you'd like.
Sure, yeah. I do believe the way it was phrased, as Mr. Aurora points out, is asking if it could be misleading to someone else, and that would be speculation. So if you can keep it just to Detective Booth, what's within his personal knowledge, you may continue. I'm going to sustain the objection. You may rephrase, though, if you would like.
Thank you, Your Honor. Detective Booth, when you held back that relevant evidence at the preliminary hearing, did you think that that might be misleading?
No.
Detective Booth, regardless, let's be clear, you weren't trying to hide anything from the jury at that time.
No, I was not.
Okay, with that in mind, when it comes to interviewing suspects, you make sure that you're paying attention to what they're actually saying.
Yes.
Right, because it's not just what they're saying, but how they say it.
Yes.
And that's another reason why you would pay attention to body language.
That's correct.
Especially someone like my client, although you didn't mention this on direct, is saying things like, I didn't mean to, or I didn't know what I was doing, right?
Objection, Your Honor, hearsay.
Ms. Forrester, response?
Your Honor, on direct, opposing counsel solicited specific statements that were made by Mr. Ray during the interview. Under the rule of completeness, these additional statements would be admissible.
Mr. Aurora?
Your Honor, these are separate statements, and the statements I elicited on my direct examination were statements by our party opponent. In this case, the defense has no party opponent. They're still separate, inadmissible statements.
Mr. Aurora, the statements that Ms. Forrester is asking the witness about, do those come from the same document as the statements that you elicited on direct examination?
Yes, Your Honor. They come from the same. They come from the same interview, but they're made at different points.
All right, but it is from the same interview.
Yes, Your Honor.
All right, I will allow it.
So again, Detective Booth, when you're listening to an interview and someone says things like, I didn't mean to do it, or I didn't know what I was doing, seeing how they say it, that can be relevant.
Yes,
And these interviews, they're recorded.
they are.
Right, because it's part of Skeleton Police directives that these interviews are recorded whenever possible.
That's correct.
And the interviews were actually recorded in this case, right?
Yes,
But we don't have that video today, do we, Detective Booth?
we do not.
Right, because in your mind, the transcript was enough.
Yes,
But Detective Booth, this transcript doesn't show how Mr. Ray was acting.
that's correct.
The transcript doesn't show his mannerisms.
That's correct.
The transcript doesn't show his body language.
That's correct.
So today, what we're left with, what the jury is left with, is this transcript and no video, because in your mind, collecting that relevant evidence would have been a waste of everyone's time.
I said that, yes.
No further questions.
Mr. Aurora, do you have a redirect?
Briefly, Your Honor.
Go ahead.
Detective Booth, when you first saw the defendant right after he was arrested, was he speaking coherently to you?
Yes, he was.
And based off your interview with him, why did you not find it necessary to interview any other suspects? Were there any other suspects?
There were no other suspects, but this was a closed and shut case. He confessed to the crime, and then when I conducted my follow-up investigations, the facts were consistent with what the defendant told us.
No further questions, Your Honor.
All right, Detective Booth, you may step down so you can turn off your audio and video. Prosecution, do you have another witness?
Yes, Your Honor.
All right, you may call your witness and proceed when ready.
Your Honor, at this time, the prosecution calls Dr. Mac LaGreca. Please introduce yourself to the members of the jury by stating your full name and spelling your last.
Dr. Mac LaGreca, Lagreca.
What do you do for a living, Dr. LaGreca?
I'm the program director for West Carolina School of Medicine's Forensic Psychiatry Fellowship Program.
What is forensic psychiatry?
It's a subsection of psychiatry that focuses on the relationship between psychiatry and the legal system. We consult with attorneys, law enforcement, and courts if we need to provide expert testimony.
Have you provided expert testimony in the past?
I have. An expert witness in 7 criminal trials. 5 of those trials included mental illnesses like schizophrenia and anxiety disorder.
Can you walk us through your educational background?
Sure. I earned my bachelor's degree in chemistry at the University of Delaware in 1985. Afterwards, I earned my medical degree at the University of Pennsylvania. I went on to complete my residency in psychiatry at UCLA. I then returned to the University of Pennsylvania to complete my fellowship in forensic psychiatry.
Where did you work after completing your residency?
After completing my fellowship, from 1994 to 2017, I owned my own private practice. It was called LaGreca Psychiatric Associates in New Jersey.
And what did you focus on there?
I worked with a diverse population of patients, diagnosing and treating a wide variety of mental illnesses, including schizophrenia and anxiety disorders.
Are you board certified in forensic psychiatry and neurology?
Yes.
Now, how did you first get involved with today's case?
I was retained by the state of West Carolina to provide an opinion regarding Mr. Timothy Ray's mental illness on October 17, 2018, the day he killed Nathan Ray. I then created a report based on my findings.
Are your opinions based on sufficient facts and data?
Yes, they are. I reviewed all exhibits and materials in preparation of my report, including the report made by Major Riley, the defense psychiatrist, including his interview with Mr. Timothy Ray and interviews with Mr. Timothy Ray's close friends and family. I also reviewed statements made by law enforcement. This includes statements made by Detective Booth, Officer Wentz, and the interrogation by Officer Booth of Mr. Timothy Ray.
Are your opinions the product of reliable principles and methods in the field of forensic psychology?
Of course.
Did you reliably apply those principles and methods to the facts of this case?
Yes, I did.
Dr. LaGreca, are all of your opinions held to a reasonable degree of medical and psychiatric certainty?
Yes.
At this point, Your Honor, prosecution moves to tender Dr. LaGreca as an expert in the field of forensic psychiatry.
Any objection?
No objection from the defense, Your Honor.
All right, they are so admitted as an expert.
Dr. LaGreca, you mentioned you were retained to provide opinions in this case. Did you come to any opinions?
Yes, I actually came to 3 opinions. The first opinion, Mr. Timothy Ray did not suffer from any severe mental disorder, including schizophrenia. My second opinion, Mr. Timothy Ray manifested signs consistent with malingering, especially during his interview with Major Riley. And my third opinion, the very unlikely circumstances that someone would suffer from schizophrenia and are not malingering, they should still be able to tell right from wrong.
I want to talk to you now about your first opinion that the defendant did not exhibit signs and symptoms of schizophrenia. Can you tell us first what schizophrenia is?
Sure. So schizophrenia is a neuropsychiatric disease. In layman's terms, it's a brain disorder. Less than 1% of the world's population suffers from schizophrenia.
And how's a proper diagnosis made?
Proper diagnosis is made with something called the DSM-5, which stands for the Diagnostic and Statistical Manual of Mental Disorders in the setting of clinical evaluation.
And what factors did you look at in this case?
The 2 main factors I looked at in this case were hallucinations and delusions or paranoia.
Okay, let's go through these one at a time. First, what's a hallucination?
In layman's terms, hallucinations involves sensory response to a non-physical stimuli. So hallucinations can include hearing, seeing, feeling, smelling, or even tasting things that are not real. For example, auditory hallucinations involves hearing voices or sounds that don't have a physical source. And this is actually the most common type.
Is it your opinion that the defendant was suffering from hallucinations before October 17, 2018?
No, it's not.
Why not?
So looking at Mr. Timothy Ray's past, there's no evidence of him suffering from hallucinations. There was one instance in 2010 while he was in the military that his commanding officer, Officer Cruz, reported that he was having visual hallucinations. But based on Major Riley's complete psychiatric evaluation, Mr. Timothy Ray explicitly denied this.
What was the conclusion of Major Riley's psychiatric evaluation?
At the time, Major Riley diagnosed Mr. Timothy Ray with generalized anxiety disorder, and Mr. Ray was then discharged from the military.
Did the defendant see any other doctors after he was discharged?
Yes. After being discharged from the military, Mr. Ray saw a family medicine physician, Dr. D. Giuseppe, 3 times between 2010 and 2017.
Did the defendant tell anyone else that he was having hallucinations?
No, Mr. Ray did not tell anyone that he interacted with the most. This includes his father, his wife at the time, and his boss. None of them complained of him exhibiting these symptoms or observing them firsthand.
So when did the defendant report he was having hallucinations?
The only time Mr. Ray told anyone of these hallucinations was to Major Riley, and this was notably after his arrest. Even then, we don't know that the voices that Mr. Ray was complaining about can even be considered hallucinations.
Why is that?
So, like I mentioned before, hallucinations as part of schizophrenia are external sounds to the person hearing them, believing that other people can hear them too. Now, this is different from thoughts, from anxiety and depressive thoughts that are more internal voices. The things Mr. Ray alleges he hears can be considered anxious and depressive thoughts, not hallucinations.
Okay, so you concluded that the defendant did not suffer from hallucinations before October 17, 2018. So let's go to the next factor that you mentioned, which was delusions or paranoia. Can you tell us what paranoia is?
Sure. So before I tell you what paranoia is, I'd like to elucidate delusions. Delusions are fixed beliefs.
Objection, non-responsive.
Ms. Naughton?
Your Honor, can I confer with co-counsel, please?
Your Honor, we also move to strike that statement.
I'll allow Ms. Naughton to confer with her co-counsel first before making my
Yes, Your
ruling.
Honor.
Thank you, Your Honor. Your Honor, may we proceed?
Do you have a response on the objection?
Yes, Your Honor. The delusions that he was experiencing, they're complex, and it's just something that needs to be broken down for the jury. So our expert's just trying to explain what that is.
Your Honor, may I respond?
I don't think it's necessary. I'm going to sustain the objection at this time. You did ask about paranoia and he started answering about delusions. However, feel free to ask about both as well, but I am going to sustain that particular question and answer as non-responsive, and it will be stricken. You may proceed.
Did you find that the defendant suffered from paranoia before October 17, 2018?
No, like with the hallucinations, there wasn't any evidence of paranoia.
Can you elaborate on this?
Sure. So in the first two visits Mr. Ray had with Dr. DiGiuseppe, he did not report anything about suffering from paranoia.
What about the third visit?
During the third visit, Mr. Ray asked Dr. DiGiuseppe if she was speaking to his wife behind his back.
After learning this, is it your opinion that the defendant was showing signs of paranoia?
No, not at all. Mr. Ray was suspicious of his wife, but he had good reason to be. It turned out that his wife at the time was having an affair, so his alleged paranoia was not paranoia at all.
Objection, relevance.
I'm sorry, could you restate your objection, Mr. Caddis?
Relevance, Your Honor.
And Ms. Naughton, response.
Your Honor, this is relevant. May I make an offer of proof?
I will assume we are now at sidebar. Yes, you can make an offer of proof.
This witness is going to testify that the defendant was actually not having any paranoia about his wife having an affair because she actually was having one. So this is just relevant to show that the defendant was not exhibiting any signs or symptoms of schizophrenia.
Mr. Caddis?
Your Honor, the crux of this entire case is in regards to Mr. Ray's mental illness his mental state, and any mention of an affair that hasn't been validated in this case would be irrelevant.
Does that mean that you will not be having Dr. Riley testify regardless at all about this affair or about your client's potential paranoia as a result therefrom?
We will be talking about the particular relationship that they had. However, we will not be making reference to any affair, Your Honor.
Do you concede that his relationship with his wife and whether he had any paranoia about that relationship is in fact relevant?
Yes, Your Honor.
All right, overruled. You may proceed.
Did the defendant ever tell anyone he was having paranoia or delusions?
Again, none of the individuals that Mr. Ray interacted with the most, his father, his wife at the time, and his boss, did not indicate Mr. Ray complaining of any delusions or paranoia.
So when did the defendant first bring up having any signs or symptoms of paranoia?
The first time, again, was after he was arrested for killing his son.
After going through the defendant's history with hallucinations and paranoia, do you believe that the defendant was exhibiting these signs and symptoms of schizophrenia on October 17, 2018?
No, Mr. Ray was not exhibiting signs or symptoms of schizophrenia. The only time Mr. Ray reported any hallucinations or paranoia wasn't until he was arrested for his son's murder. And this leads to my second opinion, that Mr. Ray was malingering.
Let's talk about that second opinion. What is malingering?
So malingering, like with schizophrenia, is defined by the DSM-5. It's either making out physical or psychological symptoms or grossly exaggerating them. In layman's terms, it's faking symptoms, and it's motivated by external factors.
What would an external factor be in this case?
An external factor for Mr. Ray would be evading criminal prosecution.
Objection, Your Honor. We discussed this particular issue during motions in limine.
Can you elaborate on that, Mr. Caddis? I remember you referring to a specific study that involved capital punishment, and yes, I will be considering this outside of the earshot of the jury and at sidebar. I did rule that that study could not come in. Are you referring to a different ruling of mine, or is that what you're referring to?
That's what I'm referring to, Your Honor. It's just a fear at this point in time that opposing counsel may be eliciting something from the witness that would be in reference to a life sentence or capital punishment. She just mentioned something about criminal prosecution and a potential punishment.
All right, Ms. Naughton, I trust that you do not intend to violate my pretrial ruling. I don't find this particular question and answer objectionable. However, please do abide by it. I expect that capital punishment certainly will not be mentioned, nor that specific study. You may proceed. Objection is overruled at this time.
Yes, Your Honor.
Now, how did you come to your conclusion that the defendant was malingering?
Just how the DSM-5 gives us factors to diagnose schizophrenia, it also gives us factors to consider whether a person is faking their symptoms.
And which of these malingering factors apply to the defendant?
The two factors to focus on in this case would be Major Riley's assessment of Mr. Ray after he was arrested. This occurred in the context of a criminal evaluation. And the second factor are the major discrepancies between the symptoms described by Mr. Ray during his clinical interview with Major Riley and the symptoms documented in written materials, including the medical records prior to his arrest and the interviews by the individuals that know him best.
So to that first factor, why does it matter that the defendant's assessment was in the context of a criminal evaluation?
Malingering is much more likely to occur when faced in a criminal context. Here, Mr. Ray just murdered his son, and his only way to evade criminal prosecution is to say he is schizophrenic.
Now let's talk about that second factor of discrepancies. What discrepancies are we looking for?
Well, with Mr. Ray's statements, he has certain symptoms that the objective findings just simply do not show. The objective findings, including his full psychiatric evaluation by Major Riley, 3 doctors' visits with Dr. DiGiuseppe, they all do not have objective findings of any hallucinations or paranoia. But after being arrested, Mr. Ray is now reporting them in the clinical interview.
Dr. LaGreca, let's talk about your third and final opinion. If someone suffers from schizophrenia and isn't lying about it, that they can still understand right from wrong. And how can we know this?
Sure. So several factors to consider include whether someone hid evidence or someone feels justified in their actions.
Let's start by talking about the first one, which is hiding evidence. What's the significance of this?
Hiding evidence is a hallmark indicator that a person knows their actions are wrong. For example, someone hiding a murder weapon, throwing a gun into a lake, or burning clothes that may have a victim's blood on it.
Okay, and can you now tell us about the second thing that we want to look at, which is whether someone feels justified in their actions?
When someone understands their actions are wrong, they look to justify its cause. For example, someone steals money and they know it's wrong, so they try to justify it by saying they're using the money to feed their family.
What about the idea of punishing someone?
Yes, when you punish someone, you have a balance of what is right and what is wrong.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Dr. LaGreca, just to be perfectly clear, before today's trial, you've never been qualified as an expert to talk about schizophrenia in a criminal trial.
Correct.
Not only that, you've never had your opinions or your research tested by your peers in a published article.
Correct.
In fact, you don't have any published articles in schizophrenia or in the field of forensic psychiatry.
Correct.
So let's get into the details of this untested opinion of yours regarding schizophrenia. Now, it's your opinion that there is no chance that Mr. Ray suffered from schizophrenia, correct?
Yes.
But doctor, you're familiar with the DSM-5, right?
Yes.
Your Honor, referring court and counsel to Exhibit 17A for identification, let the record reflect that I am requesting to share my screen in regards to Exhibit 17A.
Is Exhibit 17A in evidence?
I don't believe it is at this time. However, I'll just be briefly showing it, barring any objection from prosecution, Your Honor.
Before I ask about prosecution stance, are you seeking to admit this document into evidence or only to show it for demonstrative purposes?
Just to show it for demonstrative purposes at this time, Your Honor.
Ms. Nahn, do you have any objection to that?
No objection.
All right, you may proceed.
Dr. LaGreca, let's go over some of the symptoms described in the DSM-5, as well as some of the symptoms observed in Mr. Ray. Now, one of the criteria required to make a diagnosis of schizophrenia is that the individual shows hallucinations.
Yes.
And you mentioned on direct examination that while Mr. Ray was in the Army, Officer Cruz reported that he was, quote unquote, seeing things.
Yes, but in Major Riley's report, he is known to be bending the truth.
Bringing you back to my question, Dr. LaGreca, I'm not asking about Dr. Riley, I'm asking about Officer Cruz. It's true that he said that Mr. Ray was seeing things, correct?
Yes, in his report. Yes.
And that incident occurred in 2010.
Yes.
Now, another criteria you look for in an individual who's suffering from schizophrenia might be delusions, right?
Yes.
And at one point in time, Mr. Ray believed that his son, Nathan, and his wife, Jessica, were planning on cutting him up with a knife and leaving him, correct?
Yes.
And that incident occurred in 2015. Dr. LaGreca?
Yes.
And you mentioned some visits to Dr. DiGiuseppe's office on direct, right?
Yes.
And during one of those visits, Mr. Ray screamed at Dr. DiGiuseppe, right?
Yes.
He accused her of listening in on his phone calls?
Yes.
Objection, Your Honor.
Basis?
Hearsay.
Response?
Your Honor, pursuant to Federal Rules of Evidence 703, these statements made by Mr. Ray were relied on by Dr. Riley, the defense expert in this case. It survives a balancing test in regards to the probative value, showing that Mr. Ray was suffering a schizophrenic episode, substantially outweighing any prejudicial effect it would have on the jury.
Response, Ms. Naughton?
Your Honor, the defendant, it's a balancing test, and these are going right to the statements made by the defendant.
I'm going to overrule the objection. You may proceed.
Now, Dr. LaGreca, he accused Dr. DiGiuseppe of listening in on his phone calls, correct?
Yes.
And that incident occurred in 2017.
Yes.
Moving on, Dr. LaGreca, so another criteria that you consider is how these symptoms might affect interpersonal relationships.
Yes.
Maybe between a husband and a wife.
Yes.
Now, Mr. Ray's wife, Jessica Ray, described him as a completely different person from when she first met him. Isn't that right?
Yes, but with good reason.
And in fact, she described incidents where Mr. Ray would lock himself in the bathroom for hours, crying, refusing to come out, right?
Yes.
And those incidents occurred before the charged offense, right?
Yes.
Now, moving on, Dr. LaGreca, another criteria that you consider is how these symptoms may affect an individual's self-care, right?
Yes.
That might include things like their hygiene.
Yes.
Now, in this case, just about every individual that's come into contact or interacted with Mr. Ray in some way, shape, or form have described Mr. Ray as being dirty or unkempt, right?
Yes.
Your Honor, at this time, permission to publish a demonstrative for the jury.
Have you shown it to Ms. Naughton?
Your Honor, before trial, when we were conferring with opposing counsel, we were attempting to exchange exhibits, including demonstratives. However, opposing counsel was not willing to do so at that time.
All right. Well, if that's the case, then I would first like you to publish, but we're going to constructively publish outside of the jury's presence. And then if Ms. Naughton has any objections at that time, she can raise them before the jury sees the exhibit.
Yes, Your Honor. Permission to publish constructively our demonstrative outside the presence of the jury.
You may. And is this Mr. Ray's symptoms? Is this your demonstrative?
Yes, Your Honor. And then there's one more bullet point right there. There we go.
All right. Ms. Naughton, I assume you have no objections to this?
No objection, Your Honor.
All right. You may proceed. And we are now in the presence of the jury.
Now, Dr. LaGreca, I wanted to go over your opinions regarding the progression of Mr. Ray's symptoms over the years. But it's your opinion that Mr. Ray didn't exhibit a progression of schizophrenic symptoms, correct?
Correct.
However, you would agree with me that an individual that suffers childhood trauma would be an example of a schizophrenic progression, correct?
It can lead to it, yes.
And Mr. Ray did suffer childhood trauma, didn't he?
Yes.
So let's start with that then. From the point that Mr. Ray suffered childhood trauma to 2010, when he's diagnosed with a general anxiety disorder by Dr. Riley, there was no progression there.
Yes.
There was no progression there? Or there wasn't?
Could you repeat the question?
From the point Mr. Ray suffered childhood trauma to being diagnosed with a general anxiety disorder by Dr. Riley, you saw no progression.
According to the objective data, no.
So in 2010, from being diagnosed with a general anxiety disorder to the first reports of him not showering for weeks, there was no progression there.
It was not detailed in the medical records.
Okay, so from not showering for weeks to his wife describing him as a completely different person, no progression there either.
No.
From being described as a completely different person to locking himself in a bathroom for hours, crying, refusing to come out, no progression there.
Objection, Your Honor. Asked and answered.
I'm going to overrule that. He's asking different specifics. You may proceed.
From being described as a completely different person, Dr. LaGreca, by his wife, to locking himself in the bathroom for hours, crying, refusing to come out. No progression, correct?
Correct.
From locking himself in the bathroom for hours, crying, refusing to come out, to accusing his doctor of listening in on his phone calls. There was no progression there.
Correct.
So let's just get this straight real quick. So from 2010, from being diagnosed with general anxiety disorder, to 2018, where in between he accuses doctor of wiretapping his phone calls, you didn't see any progression.
Correct.
No further questions, Your Honor.
Ms. Naughton, do you have a redirect?
Yes, Your Honor.
All right, you may proceed.
Dr. LaGreca, did you use the DSM-5?
Yes.
And when did the defendant report these hallucinations?
Could you be more specific?
When did the defendant begin to start reporting these hallucinations?
After his arrest.
And when did the defendant report these delusions?
After his arrest.
No further questions, Your Honor.
All right, Dr. LaGreca, you may step down, meaning you can turn off your audio and your video. I believe that also concludes Dr. LaGreca's testimony for today, which means thank you for being here today, but you may at this point leave if you would like. You're also welcome to stay for the remainder of the trial if you'd like to watch. And Ms. Naughton, does the prosecution have any further witnesses?
No, Your Honor.
Does the prosecution rest?
Yes, Your Honor.
Okay, before we move to the defense case in chief, I assume you guys would like a break.
Yes, Your Honor. The defense would request a recess as well as a time check, if that's possible.
Certainly. Would you guys prefer 5 or 10 minutes? Either is fine with me.
I'd leave it up to the court as well as opposing counsel, Your Honor.
Hearing no suggestions, I'm going to go with 5 minutes. So we'll be expected to be back here at 3:45. In between now and then, feel free to reach out to your timekeepers and get a time check. I also am assuming that the timekeepers are keeping in touch with each other and that any disputes would be raised if there were any.
Your Honor, is it possible to put the time on the record at this point in time, or would you just like that to be done off the record?
When we come back, if there's agreement as to a time, that's acceptable. We can put it on the record.
Thank you, Your Honor.
All right, so actually it looks like it's 3:41, so I'll see everyone at 3:46. All right, it's 3:46. Teams, does it appear that everybody's back from your break?
Yes, Your Honor.
All right. Now, have you had time to talk to your timekeepers? Are the timekeepers in agreement?
Your Honor, defense was able to speak with the defense timekeeper. I'm not sure if we confirmed with the prosecution's timekeeper at this time.
Yeah, we have a message from our prosecution timekeeper saying he is in the process of conferring with the opposing timekeeper, with defense timekeeper.
All right, timekeepers, you can feel free to turn your video and mics on at this time so we can get a time check.
Morning, Your Honor.
Good morning.
Good morning. The defense has stipulated to agree that defense has used 20 minutes and 8 seconds. And the prosecution is currently at 34 minutes.
And prosecution, you agree with that?
So stipulated, Your Honor.
Okay. Timekeepers, you can turn your audio and video back off. And before we begin with the defense case in chief, does the defense have any motions?
Not this time, Your Honor.
All right, you may proceed with calling your first witness.
Your Honor, the defense calls Officer Peyton Wentz to the stand.
You may proceed when ready.
Not sure if I see Officer. Oh, there he is. Okay. Officer Wentz, I want to talk to you about your observations on the evening of October 19th, 2018. Before we do that, let's start with your background. What do you do for a living?
I'm an officer at the Skelton Police Department, and I've been on the force for 4 years now.
What sort of training did you go through in order to become an officer?
Well, I went to the Skelton Police Academy, but I also participated in the Crisis Intervention Team. It's known as the CIT program for short.
Can you describe for us what the CIT program is?
Sure. It's a 40-hour training where we learn a lot of exciting information about different types of mental illnesses like psychosis and schizophrenia, how to recognize signs of different mental illnesses, as well as different methods of de-escalation.
Moving on, Officer Wentz, let's talk about the evening of October 19th. Now, what was your assignment that night?
That was a routine night shift. I was assigned to the sobriety checkpoint.
What, if anything, drew your attention?
Well, a car approached the checkpoint, and I noticed the driver looked disheveled. So I asked him to pull over and roll his window down.
Now, officer, you mentioned disheveled. What do you mean by that?
Yeah, his hair was kind of messed up and eyes were glassy. Right away, I could also detect an overwhelming body odor from the car. He also had stains on his clothing.
Officer Wentz, who was the driver of the vehicle?
Timothy Ray.
Now, after identifying the driver, what did you do next?
I went over to my partner and handed Mr. Ray's ID to him so that he could run the plates, and that way, in the meanwhile, I could go back to Mr. Ray's vehicle.
What happened when you got back to Mr. Ray's car?
He started asking crazy questions.
Crazy questions? What do you mean by that?
Well, out of nowhere, he yelled, "Are you with the CIA?" Like I hadn't told him just a little bit earlier that this was just a traffic stop.
And what did you do after he asked you if you're with the CIA?
Well, I told him, no, I'm not. I pointed to my Skelton PD badge and explained that, I'm not part of the CIA, but he seemingly didn't hear me and just kept talking.
What else was he talking about, officer?
Well, he said that he knew the CIA had been watching him, that they believed he was a known terrorist or something like that. I don't know. None of it made any sense to me. He seemed totally paranoid.
What happened after that?
He frantically said that he could hear sirens of the CIA coming to get him.
And what did you do when he told you that?
Well, I told him there were no sirens, and I again explained I'm not part of the CIA. I pointed my Skelton PD badge and explained it all over again, that this is just a routine traffic stop. But at that point, I also asked him to please step out of his vehicle.
Okay, so at that point, once you got him to step out of the vehicle, what happened next?
Well, first he asked me if he could see my CIA credentials. So again, I pointed to my PD badge and explained again that this is just a traffic stop.
And what was Mr. Ray's response when you pointed to your Skeleton PD badge?
Well, see, he kept asking these questions, so I asked him what the heck he was talking about.
And he said,
well, you know, I won't forget this moment because he turned his head and looked at me as if he hadn't noticed that I was there the entire time. And then he started doing jumping jacks.
jumping jacks. How did you handle that situation?
I told him to stop, but he just kept going as if he couldn't hear me. At that point, I also had to pull out my gun and then order him to stop.
So, Officer Wentz, once you pulled out your gun, that was the gun.
Kind of.
What do you mean by kind of?
Well, sure, he stopped doing the jumping jacks, but then he started moving his head back and forth and covered his ears.
What happened after he did that?
I was finally able to put him into some handcuffs.
So once you got Mr. Ray into handcuffs, that must have stopped it.
No, he just kept rambling to himself in a very quiet voice.
What happened after that?
Detective Booth showed up at that point and told me to drive Mr. Ray to the police station. So I put him into my patrol car.
What was Mr. Ray's demeanor once you got him into your patrol car?
He started crying and continued to talk to himself.
And what happened after that?
I eventually placed him in an interview room so Detective Booth could start his interview with him.
Now, Officer Wentz, given all this behavior, bizarre behavior that you witnessed, the CIA statements, the jumping jacks in the street, have you seen anything like this in your entire career?
No, never. I've never seen anyone act like the defendant that night.
No further questions.
Ms. Naughton, cross-examination?
Yes, Your Honor.
You may proceed when ready.
Officer Wentz, I want to talk to you about when you first pulled over the defendant. He was coherent.
Yes, he seemed to be.
He was answering all of your questions.
More or less. I mean, he was resisting a bit, but he was.
He was not slurring his words.
No, I don't believe he was at that point in time.
But he was also antsy.
Yeah, he did seem antsy and paranoid to me.
Squirrely.
Yes.
Even defiant.
Yeah, that's true.
You'd agree with me that the defendant tried to avoid being identified by you.
Yeah, it was pretty strange. I mean, I asked him for...
The defendant lied to you and said that he didn't have his license.
Your Honor, I made an objection to the prior question.
I'm sorry, what was your objection?
Speculation as to Mr. Ray purposely avoiding being identified.
Ms. Naughton?
Your Honor, we're not trying to go into the defendant's mindset with this question. It's just rather the witness's perception.
Your Honor, if that's the case, then I ask that last question to be stricken then.
I agree that the last part will be stricken. That is speculation. Just keep the testimony to Officer Wentz, what you actually observed, not what you believed that the witness or the defendant was trying to do. You may proceed.
So the defendant also tried to avoid giving you his registration.
Objection, speculation again.
I'm sorry, what was the question again, Ms. Naughton? Could you please repeat it?
Yes, Your Honor. That the defendant tried to avoid giving him his registration.
Your Honor, the opposing counsel just stated that they're not trying to get into the mindset of Mr. Ray trying to avoid any sort of identification of himself or the vehicle. So at this point, I would just object and ask that be stricken from the record.
Yeah, Ms. Naughton, you may ask what the defendant did and did not do, but I do agree that that does suggest what was going on in the defendant's mind at the time, which this officer would be speculating too. You can rephrase the question.
The defendant didn't give you his registration right away.
That's correct.
He told you that he didn't have it.
True.
But he did have both of those things.
Yes, he ultimately did.
You then walked back to your car and gave the license and registration to your partner.
Yes,
And at that time, the defendant was in his car alone.
that's correct.
So let's talk about when you got back to the defendant's car. Officer, once we can agree that the defendant's behavior noticeably changed after you went to run his license and registration.
His behavior did change in some ways.
He asked you if you were in the CIA.
That's correct, yes.
He only asked you that after you had his identification.
Yes,
He told you that he could hear sirens from the CIA coming to get him.
right.
He only asked you that after you returned to his car.
I believe so, yes.
When he got out of the car, he was acting strange,
Yes,
and that happened after you had returned to his car.
well, I mean, again, I think he was rather strange from the beginning. It was a bit odd. I could tell his car was very messy and that he was disheveled, but certainly he continued to act strange throughout the night.
Let's discuss how his behavior again changed now after you arrested him. After you handcuffed the defendant, he didn't ask you about the CIA.
No, at that point, I believe he was just rambling to himself in a quiet voice.
He didn't say that he was hearing sirens.
No, he was just talking to himself.
And once you had arrested him, all of those odd behaviors stopped.
No, I mean, he continued to ramble and speak to himself, to cry, so I can't say that he stopped being strange throughout that night.
But he didn't speak of the CIA coming to get him.
No, I don't believe he asked any questions about the CIA coming to get him when he was in the patrol car.
Or hearing the sirens.
Correct.
No further questions, Your Honor.
Redirect?
Briefly, Your Honor.
Go ahead.
Officer Wentz, given your training and experience in the field, it's fair to say that your interaction with Mr. Ray from start to finish at that checkpoint was highly unusual, correct?
Yeah, again, I've never seen anything like this in my experience. Thought it was very odd, and I expected, in fact, to see an EMT arrive, not Detective Booth.
No further questions, Your Honor.
All right, Officer Wentz, you may step down by deactivating your video and your audio. Defense, do you have any further witnesses?
Yes, Your Honor, we call Dr. Riley to the stand.
All right, you may proceed when ready.
Good afternoon, Dr. Riley. I'd like to start by letting the jury get to know you a little bit better. What do you do for a living?
Good afternoon. I'm a forensic psychiatrist. Currently, I'm treating and seeing patients out of my private practice.
And Dr. Riley, how did you get involved in this case?
I had Mr. Ray's attorneys reach out to me, asked me to review the case and give my opinion on whether Mr. Ray was suffering from schizophrenia and to what extent.
And have you reached an opinion on that issue?
I have, yes.
Now, we'll get to that opinion in a moment, but first I'd like to focus on your background. Where did you go to college?
I went to University of Notre Dame to get a bio degree.
And where did you go to medical school?
And then after University of Notre Dame, I went to the Uniformed Services University to get my medical degree. And then I went on to Walter Reed for my psychiatry residency and my subspecialty in forensic psychiatry as well.
Dr. Riley, do you have any publications in your field?
Yes, I do. I have 15 peer-reviewed articles, 2 of which are related to schizophrenia.
Have you ever testified as an expert before?
Yes, this would be 26 times, I believe.
Your Honor, we offer Dr. Riley as an expert in forensic psychiatry.
Any objections?
Yes, Your Honor. Pursuant to Rule 702, this expert has not been properly qualified as an expert.
What specifically do you believe has not been met?
Yes, Your Honor. Rule 702 strictly states that we must know about this expert's we must know whether this witness has specific technical knowledge. We must know if they have sufficient facts or data. We must know if they have reliable principles and if they reliably applied those principles in today's case. All this foundation has been not present in today's case, Your Honor.
Your Honor, if I may be heard.
You may.
Dr. Riley just testified as to where he obtained his bachelor's degree, his medical degree, where he did his residency, that he's published multiple scholarly articles, and he's testified as an expert witness 25 times 26, including today. The foundation has been laid for Dr. Riley's expertise in mental health, specifically in schizophrenia.
You have a response?
Yes, Your Honor. Rule 702 strictly states that for a witness to be considered an expert, we must know if they had reliable principles, if they actually and reliably applied those principles to the facts of today's case. That line of testimony simply has not been elicited from this witness.
And are you arguing that that testimony needs to be elicited before the witness can even be recognized as an expert, not before they can give their opinion, which actually I think that either. Or are you disputing one of those more than the other?
Both, Your Honor.
All right. I'm going to overrule the objection. Dr. Riley is recognized as an expert in the field of forensic psychiatry. Mr. Aurora, if you have objections to specific opinions or specific testimony coming out because you believe that the underlying facts and data and the methods are not there, then you may object at that time. But he is going to be recognized as an expert.
Yes, Your Honor.
Dr. Riley, is there a specific manual that you rely on when you diagnose someone with schizophrenia?
Yeah, we use what we call the Diagnostic and Statistical Manual of Mental Disorders, or the DSM-5 for short.
Your Honor, permission to publish Exhibit 17A and B for the jury. We won't be moving these into evidence, merely using them as a demonstrative.
Any objection, Mr. Aurora?
None, Your Honor.
All right, you may proceed.
Now, Dr. Riley, are there specific symptoms that you look for when diagnosing someone with schizophrenia according to the DSM-5?
Yeah, according to the DSM-5, you look for what we call positive symptoms and negative symptoms to make the diagnosis. These symptoms have to be here. You have to have at least 2 positive symptoms for at least a month. Those are delusions, hallucinations, disorganized speech, and disorganized behavior. You also have to have what we call negative symptoms, and that's the inability to manage one's emotions or some sort of social phobia. Then you have to see what area of their life is majorly impacted. The areas we look at are mostly work, relationships, or self-care. And then, of course, you rule out any substance abuse or any other medical condition.
Dr. Riley, is there anything else that you have to consider? Any associated features?
Yeah, and these features don't necessarily have to be displayed for as long as the symptoms I mentioned before, but those would be things like mood swings, anxiety, hostility, other social cognitive defects, if you will. There's other contributing factors we do take into account when referring to or diagnosing someone with schizophrenia. That would be a childhood trauma and the history of mental illness in the family.
Now, is there any final step that you have to take before you make that diagnosis of schizophrenia?
Yeah, you always have to consider, of course, whether a patient is malingering.
Dr. Riley, earlier you mentioned that you'd come to a conclusion regarding Timothy Ray's mental health on October 17th, 2018. Specifically, what was that conclusion?
Objection, Your Honor. I'd like to renew my improper opinion objection at this time.
Ms. Forrester?
Your Honor, Dr. Riley just laid out the specific procedures and manuals that he uses to diagnose someone with schizophrenia. This, coupled with the evidence that's been provided about Dr. Riley's background in his medical field, serves the foundation that would allow him to serve as a witness at this time.
I agree. I'm going to overrule the objection.
Now, Dr. Riley, again, earlier you had mentioned that Mr. Ray, you'd come to a conclusion regarding Mr. Ray's mental health on October 17th, 2018. Specifically, what was that opinion?
Well, counsel, I believe Mr. Ray was suffering from symptoms consistent with severe schizophrenia on the day in question. I also believe Mr. Ray's anxiety disorder and depression exacerbated that undiagnosed severe schizophrenia.
And do you hold that opinion to a reasonable degree of medical certainty?
I do.
All right, Dr. Riley, I'd like to talk a little bit more about that opinion, that Mr. Ray was suffering from schizophrenia and was not malingering. Did Mr. Ray display any of the symptoms that you previously described?
Oh yes, he showed several of them. In fact,
What was the first symptom that you saw?
the first symptom I saw Mr. Ray experiencing were delusions.
Your Honor, permission to publish a demonstrative reflecting Dr. Riley's statements.
Any objection? I was muted.
Your Honor, I just have a question regarding the statements that the witness is going to make or regarding the statements that the witness is currently making.
Your Honor, the demonstrative will be displayed in accordance with what Dr. Riley is saying. Every time that he speaks, the demonstrative will then reflect what he's just stated.
Yes, Your Honor, no objections as long as there's no additional text outside of what the witness is saying.
All right, and I assume, Mr. Aurora, that you have then not seen this demonstrative either because you did not want to exchange demonstratives before, is that correct?
Your Honor, I have seen this demonstrative, but I'm not sure in which context it's going to be used.
Understood. You may proceed, Ms. Forrester.
Now, Dr. Riley, what was that first symptom that you saw Mr. Ray to be displaying?
Yeah, it was delusions. I would say during my examination of him back when I was working in Walter Reed 8 years ago, he was discharged for physical and mental conditions. His commanding officer had said that Mr. Ray had been seeing things for about a month.
Objection, Your Honor, hearsay as to the commanding officer's statements.
Your Honor, if I may be heard.
Sure.
On the direct of Dr. LaGreca and in previous testimony brought up by opposing counsel, we elicited these statements about Officer Cruz's description of what Mr. Ray was and was not experiencing. I'm happy to provide the rules of evidence, but this testimony has already been elicited and mentioned.
And Mr. Aurora, you agree with that?
Yeah, I don't believe that this witness was present in the courtroom when that testimony has been presented. Therefore, it's new to him and it's still hearsay.
Is that testimony in evidence? And did your witness, Dr. LaGreca, in fact, introduce that evidence?
Not the direct statement, Your Honor, but there was mention to the witness, but there's no statement from Dr. LaGreca, I believe.
I do believe that Dr. LaGreca specifically testified that Officer Cruz said that Timothy Ray was seeing things in 2010. That was during direct examination. Your opposing counsel did elicit it as well on cross-examination. Given that testimony is already in evidence, and this is an expert testifying about underlying facts and data that he relied on, I am going to allow it.
Yes, Your Honor.
Dr. Riley, was there any significance behind the timing of these delusions?
Well, certainly. I mean, it goes against my initial suspicions of malingering. You know, malingering is an acute event, and that initial delusion I mentioned happened 8 years prior to October 17th.
Dr. Riley, were there any other times that Mr. Ray seemed to be experiencing these delusions?
No. Mr. Ray also visited Dr. DiGiuseppe, his PCP, in 2017. There, he lashed out at her and accusing her of listening to his phone calls, even calling her all sorts of obscenities. At that point, I believe Dr. DiGiuseppe was concerned enough to refer him to a psychiatrist.
Now, Dr. Riley, what was the next trait that you found Mr. Ray to be exhibiting?
The next trait would be hallucinations.
And how is he exhibiting those?
Well, Mr. Ray was having hallucinations in 2017, leading up to October 17th, 2018. He mentioned in the interview that he was having auditory hallucinations since the age of 10. Male voices telling him to hurt people would pop up. And he also mentioned things about seeing triangles changing sizes and colors.
Dr. Riley, what was the next trait that you saw Mr. Ray to be exhibiting?
That would be this dysphoric mood. So that's like depression, hostility, or mood swings, anything under that.
Now, Dr. Riley, how did you come to find that Mr. Ray was exhibiting any of those things?
Well, first, I was able to interview his wife, Jessica Ray. She told me that Mr. Ray had always been showing signs of mood swings. I believe it was also through my interview with her, she also mentioned how he would lock himself in the bathroom for hours and just wouldn't come out. She also described him as a completely different person in 2017.
Was there any other time that Mr. Ray seemed to be exhibiting a dysphoric mood?
Yeah, and that I found out through his through interviewing his boss, Ms. Naja Jacobs. He had, I believe, roughed up a coworker and was threatening to kill him after putting him up against a wall. To me, these are just clear signs that Mr. Ray was not in control of his emotions and was just acting hostile. And these are all traits we see associated with schizophrenia.
Dr. Riley, what was the next trait that Mr. Ray seemed to display?
That next trait would be paranoia and anxiety.
How did you learn that he was experiencing paranoia or anxiety?
Oh, both were seen multiple times. I mean, when Officer Wentz stopped him at the sobriety checkpoint, he made comments about him being part of CIA and them accusing him of being a terrorist.
Dr. Riley, did you ever personally experience this paranoia or anxiety from Mr. Ray?
Yeah, during my interview with him after his arrest, he had talked about, I believe, thinking something's in the microwave or like a camera in the microwave or something like that. Just more delusions.
Dr. Riley, what was the next trait that you noticed Mr. Ray was exhibiting?
So those would be like contributing factors. So things like a history of mental illness in the family and then childhood trauma.
How did you find that Mr. Ray was exhibiting either childhood trauma or a history of mental illness?
That would be during my investigation when I talked to his father, Abe Ray. Abe Ray would just talk about how his mother was neglectful and cruel to Mr. Ray, Mr. Timothy Ray, when he was a child. And then also we found out that she was institutionalized herself.
Dr. Riley, what was the next symptom that you found Mr. Ray to be displaying?
So then the next symptom I was looking at were things that we would call negative symptoms. So he was having cognitive deficits. In other words, being socially awkward.
Dr. Riley, this list, it seems pretty extensive. Was there anything else that you noticed?
Well, yeah, the hallmark negative symptom that we most commonly see in schizophrenia would be lack of self-care. And this was how so? Well, his wife first described Mr. Ray of not showering for about a week. Detective Booth would even describe Mr. Ray as disheveled and unkempt when they would see each other at their child soccer practices. And then again, when Officer Wentz stopped him, he himself was saying how disheveled he looked.
Dr. Riley, did you ever consider if any of these symptoms were the result of an underlying mental condition or the effects of any substances?
I considered it, but no, I did not conclude that at all.
Did you ever consider if Mr. Ray was malingering?
Well, yes, you always have to consider that.
Well, what was your conclusion there?
Well, based on the lengthy history of his symptomatic traits that predate this incident, this unfortunate incident, I have to look the other way essentially and say this wasn't malingering. This is a long history of schizophrenic associated symptoms.
Now, Dr. Riley, given all of the observations you made, all of those symptoms, what is your opinion as to Mr. Ray's mental state on October 17th, 2018?
Well, it's my opinion that on that day, Mr. Ray was suffering from symptoms consistent with severe schizophrenia.
How did you come to that opinion?
Well, based off of all the symptoms that we talked about, the positive symptoms, hallucinations, delusions, and the negative symptoms, lack of self-care, social cognitive deficits, all those things just look, according to the DSM criteria, lean towards schizophrenia.
Now, Dr. Riley, when someone is experiencing those symptoms, those delusions and hallucinations, when they're in the middle of a schizophrenic episode, are they able to tell right from wrong?
Well, that's the thing. By definition, someone who's experiencing those symptoms aren't in touch with reality. So any sense of right and wrong is totally lost.
No further questions.
Cross-examination?
Yes, Your Honor.
You may proceed when ready.
Major Riley, you believe the defendant is schizophrenic, right?
Yes, I do.
And the vast majority of this is based off the defendant's self-reports.
Yes.
based off his self-reports of hallucinations
Yes.
and self-reports of delusions.
Well, I would say it was also reported by all the other people I interviewed.
We'll talk about that in a second, but for right now, I want to talk to you about something you mentioned on direct examination. You mentioned that how history of mental illness, how genetics, that can lead to schizophrenia, right?
I wouldn't say genetics, counsel. I would say having a family history does increase the propensity of leaning towards schizophrenia, but genetics, that's not something I would go as far to say.
So family history, like the defendant's mother, right?
Correct.
You didn't speak to the defendant's mother.
Sorry?
You didn't speak to the defendant's mother, right?
No, I did not. But from my interview with his father, Abe Ray.
Let's talk. I'm sorry, Major Riley. Let's talk about that interview with the defendant's father. You spoke to him, right?
Yes.
The father didn't appear to have any mental illnesses whatsoever.
No, I don't believe he did.
Now, you yourself first saw the defendant on April 26, 2010.
Correct.
And you conducted a full psychiatric evaluation.
Yes, I did.
The defendant denied having delusions.
Mm-hmm.
That's a yes.
Yes, counsel, sorry.
The defendant denied having hallucinations.
Correct.
Major Riley, you're certainly aware that the defendant saw another doctor in today's case.
Yes.
He saw a couple, but let's talk about Dr. DiGiuseppe. The first time the defendant saw Dr. DiGiuseppe was between 2010 and 2011.
I believe so, yes.
Once again, the defendant denied hallucinations.
I'd have to refer to the exhibit, but I believe so, yes.
And the defendant, once again in this interview, denied having delusions.
Yeah, but I also believe his last interaction with Dr. DiGiuseppe, he was exhibiting delusional behavior, like I mentioned earlier.
We'll certainly get there, Major Riley, don't worry. But I want to talk to you about this first one first, this first interview with Dr. DiGiuseppe. Okay. No hallucinations, no delusions, right?
None reported at that time, correct.
None reported. So let's go on to the next one. In 2014, the defendant again saw Dr. DiGiuseppe.
Yes.
Again, in 2014, the defendant didn't claim to have hallucinations.
Correct.
And again, in 2014, the defendant didn't claim to have delusions.
Yes, that is correct.
Now let's talk about that third time when the defendant saw Dr. DiGiuseppe. That was right before he murdered his son, right?
Correct.
Defendant didn't tell the doctor he was having hallucinations.
He didn't say it, no.
Right, and he also didn't say, "Doctor, I'm having delusions," did he?
Well, that's the thing. When someone's exhibiting symptoms, it's the physician's job to observe that, which is what I believe Dr. DiGiuseppe
right.
did.
What, like you just said, when someone is exhibiting symptoms, when someone tells the doctor, "Doctor, I'm having the symptom." I'm asking you a specific question here, Major Riley.
Mm-hmm.
The third visit, the defendant didn't tell the doctor he's having hallucinations.
He didn't say it, but what I was getting to is that Dr. DiGiuseppe made a clinical observation that he was in fact having delusions, just by accusing her of listening on his phone calls and calling her, some expletives, things of that nature.
Major Riley, I'm going to ask you a very simple question here.
Mm-hmm.
This third visit, the defendant didn't explicitly tell the doctor, "I'm having delusions," right?
Correct.
Now I want to move on and talk to you about another doctor. That's Dr. Nershiam, right?
Yes.
Dr. Nershiam completed a complete mental health evaluation of the defendant.
Mm-hmm. That's correct.
The defendant didn't claim to have hallucinations.
Yes.
And the defendant didn't claim to have delusions.
That's correct.
Now, while you wrote your report today, you thought it was very important to speak to the defendant's family, right?
Yes.
So you spoke to the three people closest to him: his father, his boss, and his wife.
Yes, I did.
All three told you that they never saw the defendant suffer from a hallucination.
Well, correct.
All three told you they never saw the defendant suffer from a delusion.
Correct. But they did report other symptoms associated with schizophrenia.
All three told you that the defendant never told them about any hallucinations.
Correct.
And all three told you that the defendant never mentioned to them about any delusions.
That is also correct.
So Major Riley, before his arrest, let's get this perfectly clear. No one saw the defendant experience a hallucination.
Correct.
No one saw him experience a delusion.
Well, I'd have to disagree with that because of what Dr. DiGiuseppe described in 2017, his delusional behavior prior to the incident in question.
Besides that third time, no one has overtly seen any of these things until the defendant's arrested, right?
Correct.
Doctor, you're certainly aware of the medical term called malingering.
Yes, I am.
That's when someone lies or grossly exaggerates their symptoms.
Yes.
Now, as a forensic psychiatrist, you're always concerned about malingering, right?
Yes, I am.
And you're always concerned because people have an incentive to fake their symptoms.
Yes, yes.
They have an incentive to fake their symptoms to evade criminal prosecution.
That is correct. And that's something, you know, we look at in a compilation of all sorts of symptoms.
Doctor, the more serious the crime, the more likely it is someone is faking their symptoms.
Yes, the more likely, but I'd caution in equating likelihood or association with causality.
I'm not asking you about causality, doctor. I'm simply asking you, the more serious the crime, the more likely it is someone's faking their symptoms, right?
Yes.
A murder charge is the most serious crime one can commit.
I would agree, yes.
So in a case like murder, there's a much higher likelihood of malingering.
Yes, there's a higher likelihood.
Doctor, you're aware that the defendant is being charged with murder in today's case.
I'm aware, but you have to not only look at his context, but you have to look at his history, which is why I concluded that malingering wasn't the case in this situation.
But let's talk about his history, doctor, because a strong indication of if someone's malingering is if there's discrepancies in a person's story, right?
Could you repeat the question, counsel?
Sure. A strong indication of malingering is if there's discrepancies in a person's story.
That is one interpretation. Yes, that's correct.
Especially as it relates to small details.
That is correct, yes.
Major Riley, you yourself found discrepancies in the defendant's story.
I did.
First, the defendant told you that Nathan destroyed his personal laptop.
Yes.
Then he changed his story.
Yes, but I would actually...
The defendant changed his story and told you that he destroyed his work laptop.
Well, I would actually characterize that as a memory deficit, which is a more rare symptom seen with schizophrenia. Because during that interview, you're correct, he did have a discrepancy in his story. But when I asked him about it, he started becoming hostile and dysphoric mood, if you will.
Thank you, doctor. I don't want to talk about his hostility. I don't want to talk about any of that. If you want, your attorney can come up here after I'm done and you can certainly talk about that. But for right now, I'd like to focus on malingering. Is that all right?
Yeah. All right.
A strong indication of malingering is if there's discrepancies, right?
Correct.
You found you found more than one discrepancy in the defendant's story of malingering.
Yes.
There's a discrepancy about his personal or work laptop, right?
Correct.
But then there was another discrepancy.
Yes.
The defendant told you that Nathan smashed his laptop.
Correct.
But then he changed the story.
Correct.
He changed the story and said that Nathan spilled juice on his laptop.
Yes, he did. He did.
It's entirely possible that the defendant is grossly exaggerating his symptoms.
Well, it's still a possibility.
And it's entirely possible that the defendant is lying about his symptoms.
Yes.
And doctor, you can't say with certainty that he's not.
I can say with certainty from looking at the whole picture, but I won't necessarily disconclude that he could not potentially be malingering. That is a working diagnosis, as with severe schizophrenia.
Mr. Riley, I'm going to ask you not to confuse the jury. I'm asking you a simple question here. You can't say with certainty that the defendant isn't lying, can you?
No.
Thank you. No further questions, Your Honor.
Ms. Forrester, do you have a redirect?
Yes, briefly, Your Honor.
Go ahead.
Dr. Riley, does a patient have to specifically tell you that they've experienced a symptom in order for you to recognize it?
No, counsel. I mean, the thing about schizophrenia, as a physician, we treat it also like any other pathological disorder. Say someone had a heart attack, they're not going to say, "Hey, doc, I'm having a heart attack." If I can see they're having chest pain, if I can see they're perspiring, if I can see left shoulder discomfort, I can make that conclusion on my own.
And finally, doctor, do you believe Mr. Ray was malingering?
I do not believe Mr. Ray was malingering.
No further questions.
All right. Thank you very much, Dr. Riley. You can turn off your audio and your video at this time. Feel free to stay to watch closing arguments, but neither doctor needs to stay. They're both excused if they would like to be, and I thank them for volunteering their time to help us out. Counsels, would you like a brief break before proceeding with closing statements? Well, actually, first, I'm sorry, defense, do you rest your case in chief or do you have any more evidence to present?
No, Your Honor, we rest our case.
All right, then would you like a brief break or would you like to just go straight into closings?
Your Honor, the state would like a brief 5-minute recess if possible.
All right, I assume you're in agreement, Ms. Forrester?
Yes, Your Honor, and could we also request a time check, please?
Sure, we'll do the same thing we did at the mid-trial break. We'll take the 5-minute break, and when we come back, hopefully the timekeepers have agreed on what the time is at that point and they can announce it.
Thank you.
All right, so it's 4:27. I will see you at 4:32. All right, it's 4:32. Are the advocates back and ready to proceed with closing arguments?
Yes, Your Honor.
All
Yes, Your
right. Okay, good. Before we begin, are there any further motions?
None from the state, Your Honor.
None, Your Honor.
Okay, if that's the case, before we move to the prosecution's closing, I'd ask that all of the jurors now switch back to speaker view, and for everyone else to be on, have their video and their audio. Thank you, Mr. Fay, for turning your video on, which reminded me of the time check. Are the timekeepers in agreement about how much time each side has remaining?
We are, Your Honor.
All right, and how much time does the prosecution have?
The prosecution has 10 minutes and 32 seconds for close.
And the defense?
The defense has 15 minutes and 49 seconds.
Okay, and you are allowed a time check if you would like to request one. If you've already worked that out with your timekeeper, that's fine. Or if you'd like to request it on the record before you proceed. Timekeepers, if you are going to do a time check, you are allowed to turn on your video and your audio. I'm sure you've worked out with your teammates whether or not you're going to actually speak or just hold up, an indication of how much time is remaining. But there is only one time check allowed per side. You all understand?
Yes, Your Honor.
All right, then I'd ask for all the timekeepers to, at this point, turn their audio and their video off, and they can reactivate it at the time of the time check if that's necessary. It looks like everybody is off. So, Mr. Aurora, when you are ready, you may proceed.
Yes, Your Honor. The defendant killed his son. Let me repeat this. The defendant killed his own and his only son, but now he's trying to get away with it. Members of the jury, we don't have to go through every single gruesome detail on what happened on October 17th, 2018, because the defendant admits it. The defendant beat his son with a belt, the defendant strangled his son to death, and the defendant stuffed his son's body in a trash bag, he drove it to the park, and he buried it. And let me repeat this, members of the jury, the defendant admits he did every single one of those things I just said. And accordingly, we have charged him with first-degree murder. Members of the jury, today we have the burden of proof. That means we have to prove to you, beyond a reasonable doubt, that the defendant murdered his son. Now, in order to prove this charge of murder, the law says we have to show you, 1, that the defendant caused the death of his son, and 2, that he did so with malice aforethought. Members of the jury, we have met our burden. We have proven to you that the defendant murdered his son. So how did we meet our burden? First, we have proven that the defendant caused Nathan's death. The physical evidence. In the defendant's house, there's that spilled juice, broken laptop, the belt. From the defendant's search history, countries that don't extradite for murder. How do I get rid of a body? Will bleach destroy a body? And from the defendant's car, that bleach, the large garbage bags, and a bloody shovel. And finally, members of the jury, from the park itself, Nathan's body, just where the defendant said it was. Now, members of the jury, if this physical evidence simply isn't enough for you, you also have the autopsy report. It shows that Nathan died from asphyxiation. It shows that Nathan died from the defendant strangling him with his belt. And finally, we have the defendant's own words, members of the jury. And I'm only going to say this one more time. The defendant admits to killing his son. So now we must look to the second element that the law defines in a murder charge, which is malice aforethought. Now, the law defines malice aforethought as killing a person willfully, deliberately, or intentionally. And members of the jury, we have proven this as well. On October 17, 2018, the defendant intentionally tied a belt around Nathan's neck. The defendant intentionally tightened that belt around Nathan's neck. The defendant intentionally tightened that belt as hard as he could. The defendant intentionally tightened that belt as hard as he could until Nathan stopped crying. The defendant intentionally tightened that belt as hard as he could until Nathan couldn't breathe. And the defendant intentionally tightened that belt as hard as he could until he killed his son. Members of the jury, the defendant intended to murder his son. He got mad at his son's simple mistake. He became blinded by the rage, and he intentionally murdered his son. So you might be asking yourself, well, why are we here? Why is the defendant not in jail already? Well, that's because as soon as the defendant realized he was caught, he immediately began to think, how do I get out of this? He murdered his 6-year-old son, and now he's trying to get away with it. Now, you've heard all trial about the defendant's excuse for murdering his son, that there's voices in his head and he was just following orders. The problem with that, members of the jury, is there were no voices other than his voice screaming at his son and the voice of his crying son, which he silenced forever. We heard from Dr. LaGreca today, a board-certified psychiatrist, that the defendant doesn't have schizophrenia. Because if he did, we would expect to see these telltale signs of hallucinations and delusions. But those don't exist in today's case, members of the jury. In fact, before this murder happened, the defense's own expert, Major Riley, asked the defendant, are you having hallucinations? Are you having delusions? And the defendant denied it. And over the next 7 years, several doctor visits, he never brings up hallucinations. He never brings up paranoia. And what about the people closest to him? His boss, his wife, his father, none of them saw the defendant have a hallucination. None of them saw the defendant have a delusion. And the defendant never mentioned them. The defendant didn't tell anyone he was hearing things. The defendant didn't tell anyone he was seeing things, members of the jury, until he was arrested. Now, Major Riley, the defense's own expert, said faking symptoms, known as malingering, is really common when you're trying to evade criminal prosecution. In fact, Major Riley told us that cases like murder, with the charges the defendant is facing today, there's a much higher likelihood of malingering. And that's exactly what's happening in today's case. The defendant is trying to evade criminal prosecution. And he's trying to do so in 3 different ways. First, the defendant tried hiding evidence. Just hours after he killed Nathan, the defendant looked up, how do I hide a body? He looked up, will bleach destroy a body? He was trying to destroy Nathan's body. He was trying to destroy this evidence. But members of the jury, this wasn't the only piece of evidence that the defendant tried to destroy. He also tried to hide himself. He looked up countries that don't extradite for murder. He wanted to avoid going to prison for killing his son. But members of the jury, this didn't work. So next, the defendant tried to evade criminal prosecution by lying to Officer Wentz. When Officer Wentz stopped the defendant at the sobriety spot, Officer Wentz asked the defendant for his license and registration, but the defendant lied. He said, I don't have these. Why did he lie, members of the jury? He lied because he knows those are identifying documents. The last time anyone has ever seen Nathan alive is when Nathan was with the defendant. The defendant hoped that the officer would just let him drive away, but this didn't work either. So finally, we get to the third and most elaborate way that the defendant is trying to get away with murder. Let's picture the scene, members of the jury. The defendant lied to Officer Wentz about not having his wallet, but he eventually had to give the officer his ID. He's sitting in his car by himself, and he knows that in the back seat, there's that bloody shovel. There's those bottles of bleach. There's those trash bags, the things he used to bury Nathan's body. So what's going through his mind? He's thinking, I better think of an excuse. And what better excuse than insanity? So when Officer Wentz comes back, he starts asking the defendant starts asking Officer Booth, are you in the CIA? Do you hear these sirens? He never said this to anyone before. Officer Wentz told you that when Officer Wentz first got there, the defendant was fine. But these odd things, these quotes, are you in the CIA? Do you hear these sirens? These only came out when Officer Wentz came back, when the defendant knew he couldn't get away with it. You don't only have to take my word. Think back to what Dr. LaGreca said. Dr. LaGreca compared the objective findings to the defendant's statements. Now, the objective findings show over the course of 8 years, countless doctor visits, 2 full mental health examinations, no doctor, no family worker, no coworker, including the defendant himself, ever mentioned hallucinations, ever mentioned delusions. This is malingering. This is lying about your symptoms. But if this still isn't enough, the defense's own expert told you, I have the quote right here. He told you that he had to look the other way in regards to the defendant's malingering. He had to look the other way because he found those discrepancies. Major Riley knows that the defendant is malingering, that he's lying, and he had to look the other way. The defendant is lying about his schizophrenia to avoid going to prison for killing his 6-year-old son. Members of the jury, when Jessica Ray last saw Nathan on October 16th, she never would have thought that this was the last time she'd see Nathan alive. And the next time Miss Ray saw Nathan was when Nathan was in a casket. Now, a parent is supposed to be supportive and understanding. But when 6-year-old Nathan did something as simple as just spilling his juice, the defendant wholeheartedly did the exact opposite. The defendant killed his 6-year-old son, and he's lying about his schizophrenia to get away with it. Don't let him. Find the defendant guilty of first-degree murder.
All right, is the defense ready to proceed with their closing arguments?
Yes, Your Honor.
You may proceed when ready.
There's no question that what happened on October 17th, 2018 was a tragedy. And when a tragedy like this happens, it's normal to want to find someone to blame. But today, we have to make the difficult decision to look beyond this tragedy. Because your job here today, it's not to do the easy thing. It's to do the right thing. And sometimes the right thing, it can be the hardest thing to do. Today, the prosecution wants you to rely strictly on your emotions, to just react. But that's not what you're here to do. Your job as jurors is to apply the law to the facts and to do so dispassionately. And when you do that, you'll realize that on October 17th, 2018, Mr. Ray lost a battle with an often unseen villain, schizophrenia. And in the aftermath, he lost his only son. Now, before we get into the facts of today's case, I'd like to discuss what you're here to decide, because there are two main issues before you today. The first, did Mr. Ray kill Nathan with malice aforethought? Did he premeditate it, do it willfully and deliberately? Did he mean to do it? And if he did Mr. Ray have the necessary mental state to actually commit that crime? In other words, did Mr. Ray's schizophrenia render him unable to appreciate what he was doing and the wrongfulness of that action? Now, each of these issues, it comes with its own burden. First, to prove their burden, the prosecution has to prove to you beyond a reasonable doubt. And this is the highest burden in the nation. Now, sometimes it can be difficult to understand just how high this burden really is. When lawsuits are filed and billions of dollars are at stake, beyond a reasonable doubt, it's higher than that. When the government wants to separate children from their families, beyond a reasonable doubt is higher than that. It's so high because we as a nation understand that you need to be absolutely certain when you're making such important decisions. It says right here in the jury instructions, in black and white, that beyond a reasonable doubt requires a level of moral certainty, one that leaves you without hesitation to act. But how does that apply in today's case? Essentially, the prosecution has to convince you to a moral certainty that Mr. Ray wanted his son dead, that he meant to kill Nathan. But every single thing that we've heard in today's case proves that that couldn't be farther from the truth. Mr. Ray repeatedly told Detective Booth that he didn't mean to do it, that he didn't know what he was doing. You never heard anything about the prosecution's or about Mr. Ray's plan or his intent. Instead, what you heard was a father sobbing, shocked, and terrified about what had just taken place. But it doesn't end there. Remember that video of Detective Booth's interview with Mr. Ray? That video that would have shown you exactly how Mr. Ray was acting when he said crazy things like, "I think you're with the CIA," or "They told me to do it." If I told you this was it, would you want to see it? Would you want to see this video before you made such a crucial decision? If you answered yes, he's not guilty. If you answered no, but you hesitated, he's still not guilty. Now let's say that you have no hesitation siding with a detective who ignores directives, only interviews 2 witnesses, and writes a 1-page report about the death of a child. Say that's your thing. Or that despite everything you heard to the contrary, you still believe that Mr. Ray wanted his 6-year-old son dead. Even if you believe that, even if you believe that the prosecution succeeded in meeting their burden, there's still another hurdle that they have to clear: Mr. Ray's mental health. Because Mr. Ray, he has an affirmative defense in today's case, an insanity defense. Now, before we get into the details of that defense, I'd like to discuss why we have affirmative defenses in the first place. When someone is suffering from a mental health episode, when they're in the middle of a schizophrenic episode, they aren't able to tell right from wrong. And the law realizes this. It realizes that you can't punish someone for something that's out of their control. That's the purpose of an affirmative defense. Now, Mr. Ray has this affirmative defense today, and we have the burden of proving it. But our burden is much different than the prosecution's. To meet our burden, we need what's called clear and convincing evidence. Basically, this just means you have to find it substantially more likely to be true than untrue that Mr. Ray's schizophrenia caused him to act the way that he did on October 17th, 2018. And this is a burden that we easily met today. Because what you learned today was that everyone knew something was wrong with Mr. Ray. His wife knew it, Officer Cruz knew it, Officer Wentz knew it, Detective Booth knew it, Dr. DiGiuseppe knew it, and finally, Dr. Riley, he confirmed it. He put the pieces together and he realized that Mr. Ray had been battling with schizophrenia. And it's not like Dr. Riley put this opinion together out of thin air. Dr. Riley based it on the DSM, the Bible of mental health. And he also based it on observations made by those closest to Mr. Ray. As an expert with scholarly articles and decades of experience in the industry, Dr. Riley told you how he used those observations to form his opinion. An opinion that said that someone in Mr. Ray's position, they wouldn't be able to tell right from wrong when they were in the middle of a schizophrenic episode. And in order to make that accurate diagnosis, a doctor has to start at that person's childhood, not at the crime scene. Because when Mr. Ray was just 3 years old, his mother, she refused to feed him. She forced him to take ice cold baths. And then when Mr. Ray was 6 years old, his mother was institutionalized for a severe mental illness. As early as the age of 10, Mr. Ray began to hear voices that weren't really there. These are all early signs of schizophrenia. And then Mr. Ray had more symptoms. In 2010, 8 years before the incident, Mr. Ray's commanding officer, Officer Cruz, stated that Mr. Ray had been seeing things for nearly a month. He'd been experiencing delusions. And then in 2017, a year before the incident, more delusions, this time at Dr. DiGiuseppe's office. Dr. DiGiuseppe, Mr. Ray's primary care physician, the person who knew him best, described to Dr. Riley how on that day, Mr. Ray just snapped. Mr. Ray accused Dr. DiGiuseppe of wiretapping their phone calls. He called her a bitch. This concerned Dr. DiGiuseppe so much that she referred Mr. Ray to a psychiatrist. She set up an appointment for the very next day. A clear sign of schizophrenia. And the signs, they don't stop there. Because Mr. Ray, he also experienced hallucinations. He would hear voices that weren't really there, voices telling him to hurt people. He would see things on the walls, triangles changing shapes and colors. These hallucinations, they plagued Mr. Ray for most of his life. But they were especially prevalent in the weeks leading up to October 17th, 2018. And remember that a telltale sign of schizophrenia, it's how it affects your relationships. Jessica Ray, Mr. Ray's wife, she described to Dr. Riley his dysphoric mood. How he would go from feeling completely fine one minute to crying uncontrollably the next. How he'd lock himself in the bathroom for hours, refusing to come out. Jessica described her husband as a completely different person in the years leading up to the incident. More signs of schizophrenia, this time from someone who knew him best, his own wife. And remember that Dr. Riley told you that this disease, it might impact your employment. Well, remember Miss Jacobs? She told Dr. Riley all about Mr. Ray's mood swings, how one day he grabbed an employee, threw him against a wall, threatened to kill him, all because that employee wasn't listening. It's these mood swings, these violent outbursts, they're things that point to something being wrong under the surface. Things that point to schizophrenia. Now, on the day that he was arrested, Officer Wentz saw it too. When Mr. Ray arrived at that checkpoint, he was completely paranoid. He was disheveled, frantic, hearing voices that were talking to him, telling Officer Wentz he thought he was with the CIA. And Officer Wentz, he'd never seen anything like this before in his career. They were all signs of schizophrenia. Even Detective Booth had to admit that there were some signs of schizophrenia that aligned with how Mr. Ray was acting. It was socially awkward. It was dirty and disheveled. In fact, when it comes down to it, every single person mentioned a trait or described something that aligned itself with a diagnosis of schizophrenia. And that's just another reason why that video would have been so important. That video wouldn't have been, as Detective Booth likes to say, a waste of everyone's time. Because that video, it would have shown you exactly what everyone else had seen. That Mr. Ray was losing a battle with schizophrenia. And it was only a matter of time until he completely lost it. But what about the prosecution's witness? Their case relies completely on the faulty opinions of a doctor who, until today, had never testified as an expert in schizophrenia, had never even written an article on the topic. The prosecution wants you to believe that Mr. Ray is guilty because of what he did or said after the incident. But even Dr. LaGreca was forced to admit that there were symptoms that Mr. Ray had that aligned themselves perfectly with a diagnosis of schizophrenia. Now you might be thinking, if that's the case, wouldn't we see something more? A prior diagnosis, just something? But Dr. Riley explained to you that that's simply an oversimplification of how mental illness works, because you often can't see it until it's too late. And let's face it, mental illness, it comes with a stigma. You're different. In Detective Booth's words, you don't fit in. So it makes sense that Mr. Ray would have wanted to hide his symptoms, especially in the machismo environment of the Army, that he wouldn't have been forthcoming, telling people that he was hearing and seeing things that weren't really there. It takes those we love, and it turns them into people that we can't even recognize. And that's no different here. And that's why we're asking you today to make the difficult but right choice. Mr. Ray, he never wanted to hurt Nathan. He's not guilty. And even if he did, the actions that happened that night, they were the result of a years-long battle with schizophrenia. And as our justice system provides, as much as you may want to, you cannot hold someone responsible for things that are out of their control. Find Mr. Ray not guilty by reason of insanity.
Mr. Aurora, do you have enough time for a rebuttal?
Yes, Your Honor, I do.
All right, then you may proceed with your rebuttal when ready. And Mr. Fay, I believe it was, feel free to do a time check if you've agreed to that with Mr. Aurora.
Yes, Your Honor. So stipulated to the other witness too, or the other timekeeper, Mr. Aurora has 1 minute and 50 seconds for rebuttal.
Great. You may proceed.
Members of the jury, the defense just told you that this is a tragedy. And they're right. This is an absolute tragedy. The defendant got angry. The defendant killed his 6-year-old son. And worse, he's lying about a mental illness to get away with it. This is a tragedy. Now, the defense also told you that an insanity defense, that's our hurdle, but it's simply not. We showed you today that the defendant killed his son. Insanity is not our hurdle. It is not our burden. We just had to prove to you that the defendant killed his son, that the defendant murdered his son, and he intentionally did so. They had to prove to you that he's schizophrenic, but they simply couldn't. They couldn't because the defendant isn't schizophrenic. He's lying about his symptoms. Members of the jury, even if you find that the defendant has schizophrenia, even if you find that he isn't lying, you can still find him guilty if you find that the defendant knew right from wrong. Dr. LaGreca told us that when someone hides evidence, they know right from wrong. That when someone doesn't deny their actions, but they try to justify them, they know right from wrong. In this case, the defendant did both. The defendant tried to hide evidence. He tried to hide Nathan's body. He tried to hide himself when he looked up what countries don't extradite for murder. He tried to hide his identity when he spoke to Officer Wentz. He tried to hide every piece of evidence. The defendant also understood right from wrong, and that's why he punished Nathan in the first place. If he couldn't understand right from wrong, he wouldn't be able to understand that spilling juice is wrong. The very nature of him punishing his son means he has this concept of right from wrong. It might be different than yours or mine, but it's there. We have met our burden, and the defense has not met theirs. Find the defendant guilty of first-degree murder.
All right, everyone. That finishes up the trial for today. The judges or jurors should now complete their ballots. I'd ask everyone just to stay online. We're going to wait until I get the all clear that all the ballots are submitted, and then we'll do some brief comments. All right, I have received the all clear, so we can proceed with comments. If everyone wants to turn their video back on. And let's start with Juror Hopkins. So as far as comments go, we're trying to keep things brief. We're going to do one comment per side per juror. You can go positive or negative, whatever you'd like, but just one comment per team. Actually, before we get to the comments though, let's hear which side is which. What schools are you from?
The defense is from McGeorge.
And the state is from prosecution John Marshall.
All right.
UIC John Marshall, sorry.
All right, Juror Hopkins, if you'd like to begin.
Excellent job, everybody. Positive comment, defense. Aaron, you're a beast. Keep up the good work.
Boss.
Do you have anything else for prosecution?
Prosecution, relax more. At times, if I can use first names, Sirhan? Is it?
Surgeon.
Surgeon, sorry. Just relax a little bit more. You came off a little too stiff. It was a little off-putting, especially you had some valid points, but just the stiffness of the way you presented them.
Okay, thanks.
Okay.
All right, Juror Rusamano, I hope I'm saying that right.
Yeah, that's correct. Or you can call me Joe. That's fine.
All right, I don't have first names under your labels right now, so that's why I'm.
All right. Yeah, that's right. My bad. Pretty much what Hopkins said. I felt like you guys were a little Bob. I felt like you guys were a little tense. Maybe the tone, like when you guys were trying to inject a little, I guess, sarcasm towards how the defendant was quote unquote lying and what he had done. Like, this is a kid that got murdered, and I know that you guys know that that's serious, but try to match the tone of the case a little bit better. Defense, I think you guys were pretty good, but I felt like you may have missed a couple objections on your cross. With I felt like the picture of the dead body you probably could have objected to, and probably some of the questions by the prosecution seemed like they were leading. But other than that, you guys did a fantastic job.
And our last juror, I'm probably going to butcher your last name, so I'll let you introduce yourself.
Hi, I'm Chris Augusto Carrero. I'm all the way in North Carolina. I'm going to just say one comment for each of you with respect to style, because it's so important with a jury trial. And I would say specifically for Haley, your opening statement, while it was definitely persuasive, was more an opening argument. So I just ask, tell you to be a little cautious with that. But otherwise, fantastic job on the prosecution. And then with respect to the defense, Jenna, I really appreciated your tone and manner in your closing argument. And I know I'm only supposed to have one comment, but I really got to give a shout out to Aaron, because you really killed it for the defense there. Liked it a lot.
All right, and I'll keep mine brief as well. Just two good things I saw in the closings. I'm sorry, it was Sir John. Is that how you say it again? Surgeon? Surgeon. All right, I apologize. I loved how you quoted Dr. Riley when he was testifying and gave you that line. I'm not scoring, but I actually wrote it down because it really was such a good line. I had to look the other way on malingering, and you quoted that in your closing, and I thought that was excellent. And then Jenna, your closing, I think maybe the ending of it, the way that you pled in the alternative sort of could have used a little work, but earlier in your closing, when you first made that transition, talking about if you believe the detective who did all these horrible things wrong, well, even then, and then you moved into the insanity defense, I thought that was a really good way of framing it, because it is so hard to plead in the alternative like that. So I thought both teams did a really good job, and just, keep up the good work.
Can I say one more thing?
Go ahead.
In the closing for the defense, the use of the CD-ROM was brilliant.
Thank you.
Was very good. All right. Well, if there's nothing further, I'll let you guys go and start prepping for tomorrow. Take care, everyone, and good luck.
Thank you.
Good luck.
Thank you, everyone.
Good luck, everyone.
Good luck, guys. You're amazing. All of you.